Mr. Trask, city ready?
Yes, sir.
All right. Good afternoon, everyone. Welcome to the special magistrate hearing for today. My name is Bart Valdez. If you're here for a code enforcement case, you're in the right place. We've got an appeal that we're going to deal with first, and then we'll move on to the code enforcement. So if you're here for code enforcement, just sit tight for right now. Once again, my name is Bart Valdez. I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 25 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order they appear on the agenda. At this time, I have read and reviewed all of the hearing materials provided to me, any written submissions by anyone having an interest, any timely submitted objections, excuse me, and the materials provided by the city staff. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced in writing, and the appellant and the city will be provided with a copy by mail. Additionally, you're advised that I do not have the authority to grant you a building permit. You still must obtain a building permit for any work you intend to do on your property. All right, we're going to go ahead and swear everyone in today right now. If there's anyone who would like to present any information to me today, whether it's part of the appeal or whether it's part of the code enforcement proceeding, then the city attorney is going to go ahead and administer an oath and swear in any witnesses. So again, if you expect to talk to me about anything today, whether you're a member of the public, whether you're a participant, a party, then I ask that you go ahead and stand and be sworn. Mr. Trask, can you swear everybody in, please?
Everyone that's going to speak, please stand up. Raise your right hand. You swear the testimony you're about to give today is going to be the truth, the whole truth, and nothing but the truth? Yes. All right, thank you.
Okay, the first matter I have today is application AD 2026-01. This is an appeal of the city's determination that the non-conforming fourplex may not be rebuilt. Let me just get the appearances here. Who is here on behalf of the applicant?
Good afternoon, Mr. Valdez. Joe Spataro on behalf of Ms. Alspa.
All right, sir, spell your name for me real quick.
S-P-A-T-A-R-O.
S-P...
T like Tom, A-R-O.
Okay. Mr. Spataro, have you and Mr. Trask talked about how you want to conduct the appeal today?
We have, sir.
Okay. Step up to the mic. Mr. Trask, how do you want to proceed today procedurally on this one?
So what we'd like to do is to go ahead and put Mr. Petraglia on, have him present the staff report and all the background of the case so that it's in the record, and then the appellant would have the opportunity to add any additional information after that, whether it's through testimony or documentary evidence.
Sounds good. You agree to that?
That is agreeable, and after Mr. Trask presents, I anticipated asking Mr. Petraglia some questions and then having Ms. Alspa provide some testimony to you as well.
Okay, that sounds great. And we'll go ahead and, excuse me, each side will be permitted to cross-examine the parties who testify. So with that, I'll turn it over to the city, Mr. Trask.
So the city would call Joseph Petraglia as its witness today. Joe, if you could state your occupation and your job responsibilities here at the City of Madeira Beach.
Sure. My name is Joseph Petraglia. I'm a planner with the City of Madeira Beach, and my primary responsibilities include reviewing building permit applications for compliance with zoning and floodplain regulations.
Are you familiar with the property and the applicant for the property located at 100B Street here in Madeira Beach?
Yes.
Okay. And were you the person responsible for reviewing the permit application?
Yes.
Okay. And as a direct result of that, did you make a determination that the property owner could not proceed with the fourplex that she wanted to rebuild on the property?
Correct.
Okay. And did you issue a staff report and recommendation for today's hearing as a result of an appeal of that decision?
Yes.
Okay. And could you go ahead and go through your staff report and recommendation, please?
Sure. So the application is AD 2026-01 for Samantha, 100B Street, Madeira Beach, Florida 33701. Request is appealing the city's determination that the non-conforming fourplex may not be rebuilt. The specific code provisions are section 110-93 intent concerning nonconforming property structures and uses. 3, nonconforming structures, where a lawful structure exists at the time of the passage or amendment of the land development regulations, which could no longer be built under the terms of the land development regulations for reasons of restriction on area, lot coverage, height, or other characteristics of the structure or location on the lot. Such structure may be continued so long as it remains otherwise lawful, subject to the following provisions. Provision B being that a nonconforming structure or portion thereof, if damaged by fire, natural elements, or force to an amount equal to or exceeding 50% of its current fair market value as of the day immediately preceding such damage, may only be reconstructed in accordance with the provisions of Article V of the chapter regarding the district regulations for the district in which it is located and the floodplain management regulations established in Chapter 94 of this code or otherwise provided in the article. Section 110-95C, local business tax required. Failure to have a current required local business tax receipt where applicable in force at the time of the declared disaster would prevent Section 110-95 from applying. And then additionally, 110-96 under B6, occupational license required. Failure to have a current required occupational license in force at the time of the declared disaster will prevent the section from applying to that property. And these are just excerpts from the code. The full code of ordinances, or this particular chapter with the full sections, has been included with the agenda packet. Background. 100 B Street, located in the R1 zoning district, had a legally non-conforming fourplex that was assessed to be substantially damaged from the 2024 hurricanes, with the September 26, 2024 as the declared date of disaster. On January 7th, 2025, the city responded to an email inquiry sent by the applicant's contractor, where they were informed of the structure's non-conforming status, and they were provided information applicable to the requirements for rebuilding the fourplex. And that's been included as attachment 8. The email includes the code section currently being appealed, which outlines the occupational license / BTR requirement. At the time of correspondence, the city had not reviewed the property's BTR status, nor did the applicant or contractor provide the BTR status. The structure was issued a demolition permit on March 5th, 2025, and demolished thereafter. On May 20th, 2025, the city met with the developer for a pre-application meeting. The meeting was focused on the specific development standards for the building and did not address the presence and/or status of their BTR. In December 2025, the developer submitted a building permit application to rebuild the fourplex, and it was during this review process it was discovered that the property did not have a BTR in effect at the time of the disaster, resulting in the permit denial issue on February 5th, 2026, which is attachment 9. On March 3rd, 2026, the applicant submitted this administrative appeal to be heard by the special magistrate challenging the city's permit denial. Staff findings. The pre-existing fourplex at 100 B Street was constructed in 1948, which is before the property was mapped into the R1 single-family residential zoning district. Based on Pinellas County Property Appraiser's website, the parcel is 10,520 square feet, which equates to approximately 16.6 units per acre with a fourplex, which not only violates the city's zoning district permitted use regulations, shown in attachments 2 and 4, but it is also in violation of the current density requirements of the city's comprehensive plan of 7.5 units per acre by more than double. Chapter 110, Article 3 of the city's land development regulations includes all of the regulations for nonconformities. This article was recently amended through Ordinance 2026-02, which was adopted on March 4th, 2026. However, none of the adopted changes impacts this application. The full article, including the newly adopted changes, has been included as attachment 5 for the special magistrate's review. While there are sections of the code that allow legally nonconforming uses to be retained, or even rebuilt, none of the provisions apply if the property was operating without the legally required occupational license or business tax receipt. It is important to note that Section 110-96 states occupational license is required because before 2007, A business tax receipt was referred to as an occupational license under the city code, as shown in attachment 11. As provided in attachments 6, 7, and 10, as well as confirmation with the Public Works Department that one of the units had garbage and utilities under a different name, it is the city's position that a business tax license was required at the time of the disaster and that the property was being rented out illegally without one. In her application supplied with this appeal, the property owner acknowledges that a business tax license would have been required to retain the fourplex under the provisions of Section 110-96, but that it may be retained under Section 110-93 due to contradiction. Section 110-93 is, however, very explicit that nonconforming structures and uses are both lost if damaged in excess of 50% of the structure's value. If Section 110-93 had already allowed for the nonconforming use to be rebuilt, there would have been no need for the City Commission to add Sections 110-95 or 110-96. In fact, the clause highlighted from Ordinance 1994-824 in Attachment 12, which is the ordinance that added the current Section 110-96 to the code, explicitly states that before the section of the code was added, structures damaged in excess of 50% of their fair market value would only be able to be rebuilt in full compliance with the zoning district's regulations. City staff acknowledges the applicant has been working in good faith to rebuild the fourplex and recognizes the requirement was not identified during earlier meetings. Staff also recognizes the loss of 3 of the 4 dwelling units is a significant consequence for not having a business tax receipt, and that the property owner may not have even been aware a business tax receipt was required to rent the units. However, in consideration of the various factors, staff were unable to identify a code-compliant basis to permit the reconstruction of the fourplex. While staff will be working on ordinance updates, including a comprehensive update to Chapter 110, Article 3, nonconformities, it is still in the very preliminary, with all of the changes yet to be fully discussed or reviewed and approved by Ford Pinellas, the local planning commission, and the city's board of commissioners. That concludes the background and staff determination from me as the planner that reviewed the building permit application. Also, I included attachments 1 through 13, which have been labeled with the various code sections and email correspondence in the packet, and that's goes up until agenda packet page 79.
All right, Joe, could you go through each attachment, tell us what it is, and what's the significance of it being attached to the staff recommendation?
Sure. So the application and supporting materials, attachment 1, is the applicant's application to appeal before us today, which includes the applicant's position as well as their the city's form for an administrative appeal being completed. Attachment 2 is the city's zoning map, which identifies the property in the R1 zoning district. Attachment 3, section 110-157 of the city's code of ordinances. Which highlights what's allowed in each, an overview of the uses for each zoning district. And then section 110-177 is the specific permitted uses for the R1 zoning district. Chapter 110, Article 2, which was recently amended through Ordinance 2026-02 is attachment 5. That's the full non-conforming code section as recently amended. Attachment 6, Chapter 14, Article 3, Division 4, talks about when a business tax receipt is required, as well as Section 62-33. Attachment 8 is the initial email exchange between the city and the contractor, which is before the permitting process began, where the contractor initially asked the city on the options for the property. Attachment 9 is the building permit application plan review letter that was sent in on 2/5/2026 And then attachment 10 is the applicant's email response to that plan review letter. Attachment 11 is a page or a few pages from Ordinance 2007-111, which relates to the non-conforming section of the code, as well as attachment 12 is Ordinance 1994-824, which also relates to the non-conforming section of the code. And then attachment 13 is the public notice mailing and posting for today's hearing.
All right, so I have a few questions for you then. First of all, if you could go back to ordinance 1111, which is attachment 11. That ordinance doesn't have anything to do with non-compliance or non-conformances. It actually has to do with business tax receipts, does it not?
Hang on one second.
Yeah, on page 61 of the packet.
Thanks. Yes, this is the ordinance that changed the term for a business tax receipt to occupational license. So yes, that's correct. This is for BTRs, not for the non-conforming section.
Okay. Did you determine whether or not the city has a business tax receipt or an occupational license to this property owner that is the subject of the appeal?
Yes, there has been no business tax receipt applied or issued for this property.
Okay. All right, I don't have any other questions of Mr. Petraglia at this point. I would tender into evidence, though, pages 5 through 79 of the agenda packet and ask that they be received.
Mr. Storrow, initially, do you have any objection to me bringing into evidence as exhibit number 1, pages 5 through 79 of the exhibit packet? Okay, so with no objection, we'll go ahead and accept into evidence. I will accept into evidence as exhibit number 1, the portion of the packet, pages 5 through 79. All right, Mr. Storrow, this is your opportunity to cross-examine Mr. Petraglia. As you know, I'm going to give you a full opportunity to tell me anything you want, but this is your opportunity for cross-examination, Mr. Petraglia.
Thank you, sir. Good afternoon, Mr. Petraglia. Here we go. First of all, thanks for chatting with me earlier before we started. I appreciate it. Maybe working backwards first. The denial of the permit application at this time is based solely on the non-payment of the business tax receipt. Is that correct?
Non-application and payment of BTR. The lack of a BTR, correct, yes.
Okay. So while during a permitting process, there may be other issues that come up that the city would go back and forth with the applicant about, as it stands today, the only thing that's delaying this is the BTR.
Correct, and then the permit would be reviewed for other, but this is the only thing that's holding it up at this time, correct.
All right. And can you put into the record what the BTR is from a financial standpoint?
Yep, it's required when a rental unit is being operated in the city, business tax receipt for verifying that it's rented legally and meets standards to occupy tenants.
How much is the tax?
I believe it's $9.73 for the annual fee per unit and a $70 inspection fee.
Okay, so this property prior to the hurricane and prior to demolition was a 4-unit complex.
Correct.
Okay, so we're talking, fair to say, $40 a year at most, $30 if Ms. Alspaugh was living in one of them and renting out the other 3.
Plus the $70 inspection fee, correct, yep.
Okay, and is that an annual tax?
Yep, the BTR fee is annual, and then the inspection fee is every 2 years.
Okay, so we are also talking about what, as it relates to a penalty, if prior to demolition, or prior to the hurricane, I guess, the city had determined that Ms. Alspaugh or the previous owner was renting out the units and not paying the BTR. Like, what would have happened?
If the city determined before the hurricane that it was being rented out without the BTR, then we would send a letter to the owner letting them know that they need to apply for a BTR. And then once they obtain the BTR, it would be business as usual.
Okay. And you said, I think you told me before that there was potentially like a 20% fee that sometimes gets waived.
Yeah, correct.
So 20% of another 110, so maybe another $20.
If even, and I believe the fee is only on the $9.73 per unit inspection fee. So yeah,
Another $8.
potentially correct.
You indicated that the only thing that's currently delaying the permit is the BTR. Is it accurate that the code that you're relying on does not allow you as the planning reviewer to accept payment after the fact?
Correct.
Can you explain why that is?
It's not clear that there's a section of the code to allow us to accept payment for a BTR after it's been demolished.
After it's been demolished?
Or not specifically after it's been demolished, but as the current state, staff couldn't find a way to accept a BTR.
Did you attempt to?
Yes, I reviewed with the city attorney and the community development director, and we couldn't find a feasible route.
Okay, sorry, I'm flipping through your packet. We're talking about 11095C. Correct?
Hang on one second. That's one of the sections, particularly for rebuilding, we usually use 11096. So particularly it would be 11096C, 96B6, but also 11095C, yes.
Okay, so the general nonconforming structure statute no hurricane, right? More than 50% damage, the property wouldn't have been able to be rebuilt.
Possibly there have been situations before the hurricane where it was determined, like for example, 11095, even without a hurricane, if it's damaged more than 50% in any capacity, it could be rebuilt if
Okay.
it had a BTR.
Well, 11095 and 11096 are there to allow people with nonconforming structures to rebuild.
Correct.
All right. And you cited both, and I think you covered this, and I believe Mr. Trask asked you about the ordinance you added, but the Business Act receipt that's talked about in 95 and the occupational license in 96 are the same thing.
Correct.
So it's just one violation.
Correct.
All right. And your reading of it is that once the hurricane happened, if that wasn't paid, there's no way ever to get around it. The person can't pay the tax, can't rebuild.
Yes.
All right. So is it fair to say that for a period of the better part of a year, Ms. Alspaugh was communicating with the city verbally and in writing about rebuilding this property?
Yes.
Okay. And in those communications, were you aware that she was attempting to rebuild 4 units like the structure that was there before?
Yes.
All right. When did you issue the permit to demolish?
The city issued the permit to demolish. I believe I have it in the staff report, but it was after we sent the initial email and before the new builds permit application was applied for. The structure was issued a demolition permit on March 5th, 2025.
Okay. So when the permit to knock the building down was issued, the city did not determine that there was a BTR issue or that, well, I'll stop there. When you allowed her to knock the building down, nobody at the city reviewed the BTR issue.
Correct. That's a demolition permit is just approval that it meets the code to be demolished, which if we denied that, there would have to be some, it's very unlikely that the city would ever deny somebody the ability to demolish the structure.
Okay. But you did that knowing she was attempting to rebuild it.
Correct. It wasn't cross-referenced, but yes.
All right. What do you mean?
Like the city wasn't aware, didn't cross-reference that there wasn't a BTR until, unfortunately, the rebuilds permit was already applied for.
Right. So you didn't check on that. I'm going to say you, the city, didn't check for the BTR and allowed the building to be demolished. And before and after that permit to demolish was issued, you, on behalf of the city, were engaging with Ms. Alice Baugh's architect to talk about the structure.
Correct.
And you were answering questions about the nonconformity and the specs and the setback and things like that.
Correct.
All right. So your denial, did you tell me that it was kind of like an automated email? The one that said you need the BTR?
No, I wrote that email.
Okay.
So that's when I first reviewed the building permit application. That's the first thing I checked for. And then I realized that there was no BTR, so I requested the property owner provide some documentation.
Okay. In that email, your initial email, you indicated that the permit couldn't be issued because of that, right?
Correct.
All right. Are you aware, and I might ask you something you don't know here, are you aware of anywhere in the ordinances that talk about allowing residents to rebuild, anything in those ordinances that references that there should be some type of tax implication?
Other than 110.95 and 96.
Right. No, I'm talking about the ordinance, like Ordinance 824, the Land Development Code.
What page on the agenda?
49. Your stamp is 49 of item 5A.
So 49 of the agenda packet is where the city emailed the applicant the code sections.
Can I show you which page I'm?
Yeah. Oh, okay. Yeah, please. Oh, okay. Oh, gotcha. That's an old version. Okay, I'll pull that up 1 second.
So will you just, I don't know if for Mr. Trask, tell it and the record, which page is it on the actual?
Finding it 1 second. It's page 61 of our current agenda packet.
Okay.
Sorry, ordinance 111, is that the one?
824.
Oh, sorry, hang on 1 second. It's attachment number 12. Let me find the page. So that's beginning on page 63 of the current agenda packet.
Did you find it?
Yeah,
Okay.
page 63 of the current agenda packet.
Yeah, A24, the whereas. Is there anything in here that talks about paying taxes to, like, do you understand my question?
No.
No? Okay. If like I say, if you don't know the answer, that's fine. You're not
Can you
completely familiar with
repeat
this code, right?
This code, you're asking me if this particular ordinance requires a BTR?
Right.
This code is not in use anymore. Let me find real quick where it would have been.
It's not, I'm sorry, you included it, so maybe I'm just.
Yeah, no, it's to be included. It's just showing the history of how the code evolved.
Okay, fair enough.
And this one did require a BTR as well.
All right. So before I turn over to Ms. Alspaugh, is there anything that, as far as you can tell, the city, you're allowed to do to move this project forward?
No, the city couldn't find a way to move the project forward.
Okay. Thank you. Mr. Trask, anything else for Mr. Petraglia before I?
Have some redirect, if that's okay.
Yeah, go ahead.
Okay. So, Mr. Petraglia, let's talk about a couple things. Let's start off with the ordinance that was just being referred to, ordinance number 824.
Yes.
Okay. That ordinance was adopted what year? You want to go to the signature page, which is on 69 of the agenda packet.
That ordinance was adopted on the 18th of October in 1994.
So since 1994, there's been a requirement that an occupational license be in existence if the property owner was going to rebuild after catastrophic loss, correct?
Correct.
Okay. That has not changed over the last 31 years, correct?
Correct.
Okay. I also want you to turn to attachment number 8 in the agenda packet. That starts on page 45.
Yes.
This is an email string that was going back and forth between who?
This is between the city and the applicant's contractor.
Okay. When this email was provided, what was the time frame? Give me a date.
So this was sent on January 7th, 2025, which is when the city sent the code section regarding the rebuilding regulations, which also includes the BTR.
That was the question I wanted to get to you. So when the code provision was provided to the architect or the property owner
Contractor.
on January 7th, 2025, it included the entire code provision that related to catastrophic loss rebuilds, correct?
Correct.
And that did include subparagraph 6, which required the occupational license, correct?
Correct.
Okay. So I just want to boil this down into its simplest terms and tell me whether I'm accurate on this, okay? The property is zoned residential, correct?
Yes, single-family residential.
All right, so only a single-family residence can be placed on the property as of right now, correct?
Correct.
It had a fourplex on the property before, correct?
Correct.
That made it a legal non-conforming structure, correct?
Yes.
Okay. A legal non-conforming structure has to come into compliance with the current code once the structure is destroyed by at least 50% of its value, correct?
Correct.
What's the reason why the city wants non-conforming structures or non-conforming uses to come into compliance with the current code?
Because it's more compatible with the future land use and the city's comprehensive plan and the countywide rules and regulations.
Okay. So, but there are exceptions to that not being able to rebuild. And those are the two code sections you've been talking about today, 11095 and 11096, correct?
Correct.
Okay. And so the 110-96 is basically saying we understand the fact that there is a requirement that this property be brought into compliance with current code, but we're going to create an exception, correct?
True.
All right, and that exception is set forth in detail in 110-96.
Yes.
One of the conditions to that exemption is the business tax receipt. Did I get that correct?
Yep.
All right. So there is no legal right for a property owner to rebuild a non-conforming structure unless he or she meets all the requirements of the code under 110-96, correct?
True.
All
Yes.
right. All right, I don't have any other questions. Thank you.
All right. Does the city have any other witnesses you want to call at this time, Mr. Trask?
I just have a question for Joe as to whether or not I need to call his client under my case in chief, or does he want to present and I cross-examine? Do you have an objection to me? And the reason I'm asking is because I'm going to be tendering in some evidence that I'm going to be providing to her. Can we do it in your case in chief?
Absolutely.
Okay, sounds good. So then and again, if there's something that comes up and you need rebuttal time, we'll do that as well. So, Mr. Spataro, then this is your opportunity to call any witnesses you want to call, provide any information to me you want. And I will say this, after we're done with all the evidence, I'm going to have some legal questions for both you and Mr. Trask as well. But feel free to present to me anything you want to present at this point in time.
We'll call Samantha Alspaugh, and I'll ask, do you want her at the podium or at one of the seats?
Yeah, go ahead and step up to the podium. This is being broadcast, so there might be other people in the city that are interested in this. Plus, it's easier for your court reporter to get a record.
Okay, perfect.
Would you state and spell your name?
Yeah. Samantha Alspaugh. My last name is Alspaugh.
Okay. And as the appellant, are you the property owner at 100B Street?
Yes.
When did you buy the property?
End of 2021.
And prior to, the property was damaged in which hurricane?
Hurricane Helene.
Okay. Prior to Hurricane Helene, how were you utilizing the property?
It was 3 rentals, and then I actually bought it as a primary, so I lived there.
And tell us, how much did you pay for the property?
$824.
Okay. And do you have a mortgage on the property?
Yes.
How much do you currently owe?
$622,000.
When you say 824 and 622?
Sorry.
824,000.
And $622,000.
Okay. And as a revenue generator of the 3 units you weren't living in, what was the revenue on those?
It would have been anywhere between 5 and 6, depending on, I had a long-term tenant, and then I did 6-month leases as well. So it varied
5,000 and 6,000 per month?
per month.
Since Hurricane Helene, has any of the property, prior to demolition, was any of the property livable?
No.
At what point did you engage with the city of Madeira Beach about demolishing and rebuilding the property?
Yeah, so we had, actually, I actually don't know if the city put these on, but there was a lot of meetings that people did throughout October. And then I started engaging with the city directly in November of 2024.
From November of 2024 until January of 2025, what did you do with the property?
We had done mitigation, so took all the interiors out. And that's when I had started talking to a general contractor and an architect as well.
And what did you do in terms of mitigation?
We took all the sheetrock out, all the sheetrock and all the cabinets, and put anything that
How did you
touched
do that?
for mold.
So prior to the demolition, how much did you spend on mitigation and your architect?
So prior to, it was about $21,000.
All right. So at what point was your demolition permit authorized?
In March, I'm sorry,
March of,
2025.
all right. And leading into the demolition, can you give the magistrate a synopsis of what your understanding was from the city of the rebuild?
Yes. So we had a couple different email exchanges, my architect as well, on the options that we had, because we know that it is a 4-unit and it's a non-conforming in an R1. So we specifically asked questions around zoning, around the size that we can rebuild back. We even talked about, actually, I wanted to bring it up to kind of a single family and asked if I could just build townhomes and sell them individually so they look like single families. We went through the land use of, you can't do townhomes, but the city doesn't distinguish between a condo and an apartment building. So those are both options of what you can build back. I even talked to a Pinellas County tax appraiser on tax IDs if I decided, or, I was allowed to do condos. We discussed zoning setbacks. I was told that it's current regulations. I can go in. Do you want me to go into my interpretation of? So
Sure, I
okay.
want you to tell the magistrate your understanding of
Thanks.
Man, this is your opportunity to tell me anything you want to tell me. So, like I said, formal rules of evidence don't apply.
Okay.
You tell me your arguments, lay them out for me. Mr. Trask will be able to cross-examine you, so please feel free to tell me what you want to tell me.
Awesome. So Joseph did put in his emails, as long as it applies, as long as section 110-96 is followed, and then 110-95. I read those. 110-95 uses business tax receipt, comma, if applicable, and 110-96 says occupational license. The city, as I read it, 110-96B6, the occupational license, looks like a catch-all phrase to everything above. A single-family home is A. When I read that, a single-family home does not need an occupational license, or no one would be able to rebuild their single-family home after this destruction. When I look at 110-95 that says business tax receipt where applicable, I will say this is my own interpretation, but that residential does not need an occupational license. If we look at section 62 of the code, there's a definition section for a local tax schedule, which I did look at, and it's rentals of 5 units or more. Mine's 4, purchases a residential. So my reading of the code, as a non-code person, was that an occupational license and business tax receipt is not relevant to me.
Okay. So Ms. Alspa, at the time that you were provided that information, did you at that point realize that you were not in compliance?
I'm sorry, which part?
When you got the email about what you just said, the occupational license, et cetera, did that flag to you that you weren't in compliance and you were never going to be issued a permit?
No. When I looked at 110-96, you look at the B, which is duplex and triplexes, I believe. And then there's one that's on the non-conforming multifamily that adheres to the same as the duplexes. So I read those two as being applicable to me.
Okay. After the demolition permit was issued, how much, like we talked about kind of pre-January 2025. Since then and prior to not being issued the permit, how much have you spent?
$74,000.
Can you walk through what you've spent on?
Yes. So after the email correspondence, after we demoed it, we actually scheduled a meeting in May with the specific fact of knowing that I would like to rebuild 4 units in a non-conforming R1 zone. We sat with the city, we reviewed the plans, for the simple fact knowing that something like this would be close to $60,000 and $80,000 in engineering cost. So we sat with the city to understand what I could rebuild before I engaged those assets, because it's a lot of money. And the really only feedback we got is that I need to have a drainage pond and I have to plant 8 trees, and that I should probably put elevators because snowbirds come down here for 6 months. So after that, my architect re-engaged the plans and re-engaged with a mechanical, a structural, and civil engineering firm. And there's still, obviously, the second part of their invoices that haven't come yet because we haven't started building, but altogether it'll be about $120K.
But you spent $74,210
After May.
after May before the current permit request was denied.
Yes.
Is there anything else you want to share with the magistrate before Mr. Trask asks you some questions?
No, I don't think so.
Well, I'll ask you this. When you were first notified that you weren't going to be given a permit because of the business tax receipt, did you offer to, and in fact attempt to pay whatever taxes were delinquent?
Yes. I responded to Joe's email and actually said, what do we have to do to remedy this? That was a dire mistake on my part, and that I don't feel that the punishment fits the crime. But I did ask if I would be able to pay the back part of it.
And you were advised based on the code that the payment wouldn't change anything. Is that correct?
I do not believe that that question was actually answered in the response. The response was that he would forward my email to Mr. Trask.
Okay. Were you at any point allowed to remediate the non-payment of the VTR?
No.
Senator, the witness.
All right, Mr. Trask, let me just jump in here. I hope I don't steal your thunder. I am looking at your February 6, 2026 email, Ms. Alspaugh. Just so I'm aware, do you dispute the city's position that you never had the BTR, the occupational license, prior to Hurricane Helene?
No, I don't dispute that.
Okay, no problem. Mr. Trask, go ahead.
Just a few more questions. Is this the first time that you've ever owned rental property?
No.
Okay. Do you own other rental property now?
Yes. Not in Florida.
Okay. Not in Florida, did you say?
Yes, not in Florida.
Okay. Have you ever rented or owned rental property in Florida other than these units?
No.
As a landlord, what other state are you a landlord in?
Virginia.
All right. Is there an occupational license requirement in Virginia for rental of your properties up there?
No.
Okay. This letter, the email that you sent to the property, to Joseph Petraglia here at the city, which is marked as page 59 of the agenda packet, it was sent on February 6, 2026. That's the email that you were referring to earlier, correct? That you were asking whether or not that you could pay the late
Yes.
business tax receipt fees, correct? Is there any other email that you've sent to the city where you've discussed the business tax receipt?
Only in the formal appeal document that I sent right before during the appeal window.
Okay, all right. Earlier, Mr. Petraglia had testified that he had sent an email or been involved in an email between the city and your architect. And that email was dated January 7th, 2025. Did you see that email?
I did not.
It was never provided to you by your architect?
No.
Okay. Did you ever discuss the contents of it with your architect?
Yes, I discussed not necessarily the content of that email directly, but that email just referenced and snipped the section 110, 95, and 96 of the code. So we had already talked about that because I did not think it was relevant to me.
Okay. So did the architect tell you that there is a requirement of the code that you have to have a business tax receipt or an occupational license?
No, and I do not believe that the architect was on that. I believe that was just my general contractor, Robert Copenhaver. If you show it to me again, I can let you know. My architect's name is Alex.
Yeah, he's not on there. It's just to robcopenhaver.com.
Yes,
That's the
my general
contractor?
contractor.
Okay. So back to my questions then. Did you have a conversation with your contractor about this email?
Yeah, and it would be the same response that I gave you as far as one section says business tax receipt if applicable, one says occupational license. And if you look at both of those together and being where applicable, it looked like it was commercial only.
But did you discuss that with your contractor?
Yeah, I've talked to both him and my architect about it.
Okay. And that would have been done approximately what time? The January 2025 timeframe?
It would have been as the emails exchanged.
Well, the email we're talking about right now is January 7th, 2025. I'm just trying to get a time frame.
Yeah, and so there was also communication at the end of January as well, in which we had still further discussed what we could build, even after this section was sent to my general contractor.
Okay, so this was about 2 months before you applied for the demolition permit, correct?
Yes.
After having the discussion with your contractor or your architect or both about the occupational license requirement, did you ever ask the city about that requirement?
I did not.
All right, thank you. I have no other questions.
All right, any redirect, Mr. Spataro? I don't have any questions, so any more questions for this witness? Okay, thank you, ma'am.
Thank you.
All right, Mr. Spataro, would you like to call any other witnesses, or would you like to put anything else into evidence for this portion of the hearing?
No other witnesses or evidence, sir. Just like to make an argument at the appropriate time.
Yeah, sounds good. Okay, that appears to be the end of the applicant's case. Mr. Trask, a little bit different procedural posture than normal. I mean, normally we'd go to public comment by people affected at this point. What's your, and I don't know whether there's any members of the public that are here to comment or not.
I think we should definitely ask, because it is a public hearing, it's required to have been published as a public hearing.
That sounds fine. We'll go ahead and do that. Before we get to that, is there anything else you want to put on in the form of a rebuttal case or reply or anything like that, Mr.
No,
Trask?
sir. No, sir.
Okay. All right. Are there any members of the public that would like to come forward and provide public comment in regard to appeal number 80-2026-01 for the property located at 100 B Street, Madeira Beach, Florida? Any members of the public? Going once. Going twice. Okay. No members of the public. All right. Mr. Spataro, since this is your appeal, I'm going to let you go first for your closing statement, then I'm going to kick it over to Mr. Trask, and then I'll let you have the final word as well, since it's your appeal. So go ahead, sir.
Thank you, sir. This is in essence a life sentence for a misdemeanor. Ms. Alspa testified. I mean, clearly she did not. She didn't know she was supposed to be paying a BTR before Hurricane Helene. She made attempts to, on her own, review the code and clearly misunderstood it. I'm not suggesting that her testimony as to what she thought the code says is what the code says. The issue here is that there are, a number of reasons that the denial of the permit is legally inappropriate. It's an excessive fine. It's a violation of the concept that the land development code should be in compliance with the city's comprehensive plan. The fact that there is a tax hook that should simply be a fine in the land development code is completely inappropriate. And I understand that some of those things might not be what normally come before the magistrate. But what I would ask the court, or she would ask you to look at related to that, is the penalty for not paying your business tax receipt in Madeira Beach, if you're found to have not paid it by the city, is to pay about $10 per unit. And because it has been piggybacked onto the land development code, it now is causing, let's say at the bare minimum, $75,000 of costs that the property owners incurred, not to mention the fact that it was purchased for over $800,000 with the anticipation that it would be a revenue generating 4-unit property that is now not being allowed. And so I think that you could grant Ms. Alspa's appeal for any of those reasons, but I would also suggest that while I appreciate that Mr. Petraglia and the city, I sincerely believe have been working in good faith with Ms. Alspa, just like she's been working in good faith with them, and I think Mr. Petraglia read the code and did what he reasonably believes the code says. the fact that Ms. Alspaugh was ignorant of the law isn't necessarily a defense to not paying it, but the fact that the city moved forward and allowed demolition permits to be issued and allowed her to substantially rely and spend money on something where they didn't catch it either shouldn't penalize her. So what I'd ask the court to do at the very least is find that based on the year of interactions between the property owner and the city, including the issuance of the demolition permit, to find that the subsequent issue of the business tax receipt being identified by the city was too late in the process and grant the appeal to issue the permit at this time.
All right, Mr. Spataro, just a few questions for you. And I read pages 12 through 15, and I know there were at least two cases that were cited there. I read those two cases. Is there any other case law you want me to consider dealing with this type of ordinance to support your arguments? I just want to make sure there's no other cases I'm aware of or that you're aware of that you'd like me to review dealing with this particular ordinance, because I understand your arguments you're making.
Sure.
But are there any other cases that would give me guidance on interpreting a similar provision? Because I understand your argument saying, hey, look, she didn't pay it'd be $70 or something like that, or maybe even less, and didn't do it. Now she's only going to be able to develop or put one single family residence versus four. I get that argument. But are there any cases that will guide me to get to that conclusion?
Let me, there are. What I would say is if you're willing to entertain the excessive fines argument, then I'd ask the court to delay ruling and allow me to supplement and provide them to Mr. Trask, because I certainly didn't give him cases ahead of time. But if that argument isn't going to move the needle, then I would say no. There'd be cases on that about how civil penalties do implicate the excessive fines clause, and there certainly have been cases in Florida where that's been found to, be sufficient to at least move litigation forward. But again, having not provided them to counsel ahead of time, I'd ask to just allow to supplement on that. If that's something you're considering.
Well, yeah, and I'll ask Mr. Trask the same question. And so let me ask you this. Do you have any comment over the intent of these two particular ordinances, Section 110-95 and 110-96? And you have any authority over the intent other than what the city has provided in their ordinance going back to 1994 that had this language in it? Anything else you want to talk to me about the intent of these ordinances? And you see what I'm doing here.
Yeah, of course.
I'm trying to read the plain language, and then I'm trying to get to the intent to make sure that how I interpret these is consistent with the plain language and the intent of the ordinance.
Sure. I would ask the court to allow me to supplement on the comprehensive land use and land development regulations. There's the argument is that what this code is a land development regulation that should be consistent with the comprehensive plan. And so, again, I would ask the court to allow me to supplement with that. It's our position that the inclusion of the business tax receipt as a mandatory pre-existing condition to this exception to the non-conforming structure code is inappropriate and is not in line with what the comprehensive plan is and what Florida's legislature has in the past said is the point of the comprehensive land use plan.
All right, and to that extent, I know that I think there was some argument, it may have been in what Ms. Alspaugh provided, that there may be some state statute that was passed in regard, following the hurricanes. I mean, is there any state statute I need to be looking at or legislation I need to be looking at to guide me in how I'm supposed to interpret these two sections?
I'm
not trying to put you on the spot. I'm trying to go back and look at what Ms. Alspaugh put in her argument, or maybe you assisted in it. I'm not sure.
No. Ms. Alspaugh's appeal, she put together and filed before we were retained. So that's why I want to not necessarily rely on that. I'd rather, if the court wants a legal brief, I'd be happy to do that. I just would rather do a fresh one. And again, make sure that counsel has time to respond.
And that sounds fine. In regard to the demolition, I mean, I understand the equitable estoppel argument, or at least what you're making there. Wouldn't the property have to be demolished anyway? I mean, wouldn't that have to be something that would have to occur whether or not she can redevelop or not, seeing as it was determined to be substantially damaged following the hurricane?
I don't think we can answer that because that wasn't the plan, so that assessment was not made.
Okay.
I mean, I understand where you're going with it, but
Yeah.
I think that chases down a conclusion that we could never at this point make because they didn't attempt to do that, and now the property's gone.
Is the argument, or is your position, because one of the things I know Ms. Alspa said that she didn't believe section 110-95 and 110-96 applied specifically to her property. If I understand, one of the arguments she made is that 110-96 was it didn't apply because 110-93.3 applied. Is it your position now that 110-95 and 110-96 apply to this property and these facts we're talking about, or is your argument that this doesn't even apply at this point?
It's our position that 95 and 96 apply.
Okay.
And I think it's important to your assessment what her understanding was, but I think the reality is, from a standpoint of the code being proper and then at what point she was notified, the way the code is written, had they sent that to her and she read it and understood it, it's still a life sentence, right? It's not like she could have, had she read that then correctly, she still couldn't have come down to City Hall and paid the $40 or the $110.
And is there, along those lines, I mean, if I understood what Mr. Petraglia said, they tried to look for a way in the Code of Ordinances to see if this could be paid retroactively, but there was nothing. Did you find anything in the Code of Ordinances that would allow her to pay the local business tax or apply for and obtain the occupational license in retrospect or retroactively?
No, the current, and that's why I gave that analogy. The current city code is, if using this particular instance, at the time of Hurricane Helene, when the property was damaged, if you weren't paying your business tax receipt, the land development plan that is promulgated to allow people who had non-conforming structures to continue to have that non-conforming structure doesn't apply to you.
Okay.
It's an orange in an apple field, or an apple in an orange field, since we're in Florida.
I think I understand, but is there any authority you're aware of where I can, my understanding is my role here is to interpret these ordinances based on the plain meaning of the ordinance, and if there's an ambiguity, then the intent of the city. And so I don't believe I have any authority to rewrite these ordinances, as unfair as it may be. But are you aware of anything, and again, I'm not saying it's fair or unfair. The city in its at least 1994 ordinance expressed its intent. I understand that.
Sure.
This would be R1. It wouldn't be allowed to have 4, units on this unit if it was otherwise. If it was built today and these ordinances didn't apply. So I understand the intent, but is there any authority you're aware of, because I'm not aware of any, that would allow me to rewrite these ordinances as they're written?
No, and that's why I framed the argument like I did. I think that there's the constitutional arguments that we've discussed, but the ambiguity really falls in the factual and practical application of the code in this particular instance, being in the exchange between the city and the property owner, and then the property owner's reliance on it. So, no, I don't think that you can sit here and say, I'm going to rewrite the code, and change it. I do think you could find reasonably, based on Ms. Alspa's reliance on her and her vendor, her contractors' interactions with the city, that the finding of the specific business tax receipt issued by the city occurred past the point of no return, and they should be compelled to issue the permit.
But let me ask you that. So would it matter, right? In the sense of, there's evidence here in the record before me that she was told this as early as January of 2025, right? She was sent the entire ordinance. But would it matter anyway? In other words, if she was told the day after the hurricane, she came into the city and said, I want to redevelop my 4 units. And she says, I'm apply immediately for a building permit. And she's told at that point in time that you can't do it, you don't have the business tax receipt, you can't do it, you don't have, these sections will not apply, you're not going to be able to come in and build for rent.
It would.
How would it matter at that point? Because
financially.
I understand that she spent the $74,000 or $80,000 or whatever it is. I get that. Mm-hmm. If I understand the city's position, it's, look, we only looked at what she applied for at the time, and that was demolish the property. Anything else she did in planning on building, that's something separate. So is that what you're saying? Is if the city would have told her right away, she wouldn't have even spent the $74,000 planning to rebuild the 4 units, and therefore that's enough for the equitable estoppel to kick in here and me to say, I can't enforce this ordinance because the city didn't tell her soon enough that she wouldn't be able to do what she wanted to do.
That's my argument, and I would suggest, not that I think that this is a major sticking point, but probably closer to 100,000 because she spent 25 before that, and I'm not suggesting my client would have walked away and left a rotting piece of property here in beautiful Madeira Beach had she been told the day after, but she did certainly spend more than 74 trying to get the property
and I'll accept
clean enough to snuff.
I'll accept your reputation as your representation is 100,000. All right. Anything else you want to tell me, sir? Okay.
No,
Ms. Alspa is raising her hand. She wants to confer with you. So if you wouldn't mind just conferring with her real quick.
No, we're all set. Thank you for
Right.
being the eyes in the back of my head.
No problem, sir. I know it's a little different configuration in the courtroom like we're all normally used to being in. So, okay, Mr. Trask, I'm going to let you do your statement or however you want to do it, but I'm going to ask you some of the similar questions I asked to Mr. Spataro. But go ahead, Mr. Trask.
I just want to focus on the code itself. So section 110-93, it starts out the first paragraph. It is the intent of the land development regulations that these nonconformities shall be considered to be incompatible with the permitted uses within the city districts. Such nonconformities shall not be enlarged or extended in any respect. That's the intent that it's specifically stated in the code. As for the actual nonconforming use, I think it's clear through the testimony from Mr. Petraglia that the city has determined that the structure to be non-conforming. It's a non-conforming structure because of the fact that it's 4 units and only a single-family residence is allowed in the zoning district that he has testified about. He further provided that the non-conforming structure, once it's damaged by 50% of its current market value, and I don't think there's any dispute here so far that there is that it wasn't damaged more than 50% of its current market value. The code is very specific. It may only be reconstructed in accordance with the provisions of Article 5 of this chapter regarding the district regulations for the district in which it is located and the floodplain management regulations established under Chapter 94 or is otherwise provided in Section 110-95. So it's very clear that the only way that they would be able to rebuild is as if they brought it up to code, and that can be done a couple of different ways. They could demolish the structure. They could bring the structure up, elevate the structure, or they could leave it the way it is. Obviously, we didn't want them to leave it the way it was, having been damaged. The code is very specific, and I want to get to the issue relative to, can you pay the fee in arrears? And the answer is no. Why? Because it really isn't about the payment of a fee. It's really about what the code provides. The code says failure to have a current required local business tax receipt where applicable enforced at the time of the declared disaster will prevent this section from applying to this property. That's under 110-95. 110-96 says failure to have a current required occupational license enforced at the time the declared disaster will prevent this section from applying to that property. It's not about collecting the fee. It's about having it in place before it actually happened. And I just want to make it absolutely clear that a special magistrate understands that really it's not just about the business tax receipt. When you rent properties in the city of Madeira Beach, you have to comply with the code. One of the provisions of the code is that you have to have a business tax receipt, but as part of that, you have to have an inspection of the property. Why? Because we want to make sure that if anybody is renting a property in the city of Madeira Beach, that it meets current code requirements. So it's not just about the business tax receipt. It's not just about the dollar amount to be paid to the city, but it's also to do the inspection, as Mr. Petraglia has mentioned. It's critical that we understand that these properties are being rented, and that's the reason why. I want to talk about the excessive fine argument. There is no fine. The city has not issued a fine. The city has said there's a legal requirement for you to pay this business tax receipt, do an inspection, and pay the $70 inspection fee, but it does not say that if you don't do that, and that's not the reason why she's here, that she is here because she has to pay an excessive fine. She's here because of the fact that she applied for a building permit, and it's clear from her testimony that she absolutely knew that there was a requirement of a business tax receipt and occupational license. She testified that she had conversations with her contractor and her architect before they actually did any work on the property. I take that back. They may have done the remediation by taking out the drywall. I think that was the testimony. But it was as of January 6th or 7th, they were aware of the fact that the business tax receipt was necessary. That's 2 months before the demolition permit was applied for, and it's 4 months before the demolition actually occurred. So I think it's clear. We've gone over the intent of the code, we've gone over the exceptions of the code, and we've gone over the conditions of the code. They have not been met. I understand the position Ms. Allspaw is in. It's terrible that we had 800 or so homes in the city of Madeira Beach that have been affected by those hurricanes. We understand exactly what she's going through. But we can't make exceptions to the code. We have to apply the code to everybody the same exact way. We can't backtrack and try to fix something because the property owner didn't do what she or he was supposed to do. So we can't change the code. We can only apply it going forward. And it's clear from the testimony of Mr. Petraglia, these provisions have been in existence for over 30 years. Anybody can read the code. Anybody can understand what the requirements were, and Ms. Allspaw specifically knew it. She downplayed it because she didn't think that they really applied, but there's no question that they applied in the code. As for the cases that were cited by Ms. Allspaw, one of the cases doesn't exist. The case of Metro Dade County versus Brechtel, 625 Southern 2nd, 1245. That case does not exist. I don't know where she got that. I went ahead and pulled out the provision or the section of the reported decision at 625, 1245. That's the case of Gordon versus Freeman.
I had difficulty with that one as well, and I saw the other one. It appeared to be a Burt Harris Act claim. I don't know if it stood for the proposition cited, but
yes, the other one does exist, and it does deal with the Burt J. Harris claim in that process there. It did not deal with the type of issue that we've got here. So, in summary, we feel bad for Mrs. Allspaw. We tried to find a provision in the code that will allow us to allow her to build. We don't have one. Therefore, she has to comply with the current code. Therefore, that's the reason why the decision of Joe Petraglia was given after a lot of thought and consideration. But we're asking that you find that Joe's determination that the nonconforming fourplex may not be rebuilt be upheld, and then we'll deal with whatever else we have to deal with subsequent to that. So.
All right, Mr. Trask, I'll ask the same question you asked of Mr. Spataro. Are you aware of any case law specifically interpreting Section 110-95 or 110-96? Either these specific provisions or similar provisions that I need to look at in reaching my decision?
I don't believe you need to look at any other decisions. And I'm not aware, after being the attorney here for quite a long time, that these provisions, that there was an opinion issued on these particular provisions.
All right.
So.
And then, it sounds like Mr. Spataro agrees with me, and I think you agree with me, that I can't rewrite the codes. My role here is to interpret what is written, either the plain meaning, or if there's an ambiguity in the plain meaning, then to find the intent. Would you agree with me on that?
Yes, and I would direct you back to Section 2.5, dealing with the application to appeal. It specifically provides what you can and cannot do, but it's very clear that what you're basically determining is whether or not the decision made by the administrative official should be upheld or not. It doesn't give you the legal authority under Section 2 of the city's code to rewrite the city's code.
Okay, I agree with that 100%. Mr. Trask, this is more of a procedural question. I mean, I think I have enough information to rule, but do you want to have any more time for briefing on this issue or anything like that?
I do not. I don't think it's necessary.
Okay, all right. Anything else, Mr. Trask?
No, sir.
All right, Mr. Pastaro, I told you I'd give you the last word, so come on up. Yeah, absolutely.
Just very briefly, sir. Thank you. Appreciate council's time. So I appreciate the position of the magistrate as far as the abilities here. As I said, I think that without rewriting the code, you could make a factual finding about the timing of the application of the code and that it was improper. And I would say this as it relates to just a couple of things that counsel said. First of all, I think that the suggestion that Ms. Alspa's testimony was that the code didn't really apply to her is a inaccurate representation of what she said. And the reality is, if it wasn't about the fee, and there wasn't in essence, a fine being here, it was about the inspection, then the city would have done something about this in the years before that Ms. Alspa owned it, or the previous owner had it. Now, I don't know what the previous owner did, but as Mr. Petraglia testified to, the reason he found out about this was because the utilities were in different names. So Ms. Alspa wasn't here hiding that she was renting the units out. It wasn't like she was collecting money and putting everything in her name. If the city was so concerned about the 1948 structure's quality and sustainability, they would have checked the utilities ahead of time. This has gone on where Ms. Alspa was never notified that she had to pay this minuscule city tax or pay what, in comparison to the value of the property and how much she was spending on it, again, minuscule inspection fee. And as I said before, ignorance of the law may not be a defense, but that doesn't mean that the city can be ignorant of it as well and then say, well, that's your problem too. You made a mistake, that's your fault. We made a mistake, that's your fault too. That just should not be how this operates, and I think that the magistrate can make a finding based on that. And I appreciate counsel and Mr. Petraglia's time.
All right. Thank you, sir. Mr. Trask, I'm going to have you prepare the order. I would ask that you run it by Mr. Spataro. Mr. Spataro, I believe that the case law you represent is accurate. However, I don't believe I need more briefing on it at this point in time. However, if you want to include some additional case citations to establish your record for purposes of appeal, I have no problem if you want to put that in a footnote in the order that Mr. Trask is going to prepare. This is an appeal of the staff's interpretation of Section 110-95 and 110-96 as I see it. Based upon the testimony provided, the undisputed facts, and the legal argument, I do find that both Section 110-95 and 110-96 applies to this particular property. I do find that the city's interpretation of Section 110-95 and 110-96 as it relates to Ms. Alspaugh and her property is consistent with the plain meaning and what is written in the actual code provisions. I also find that the city's determination is consistent with the intent of the provisions in the city's provisions that are set forth in the code. Just like the city, I'm not unsympathetic to Ms. Alspaugh's arguments, but it's undisputed that there is no local business tax receipt and no occupational license. I do believe both of these apply to the property, and it says that in the event that if you don't have the required local business tax receipt under Section 110-95, then it will prevent this section from applying to that property. Similarly, 110-96-6 says failure to have the current required occupational license in force at the time of the declared disaster will prevent this section from applying to that property. Based upon the plain language of the ordinance and those specific sections, I do find that the city was correct in saying that they cannot allow the non-conforming use to continue and be rebuilt as a fourplex. In regard to the equitable estoppel argument, ma'am, I'm again not unsympathetic to your situation. I'm not convinced that you wouldn't have had to demolish the property anyway, but I certainly understand the arguments that you're making. The judge or appellate court may disagree with me on those arguments, but I don't think it would have mattered. I think it would have had to demolish the property anyway. And this is not, that concludes my ruling unless you have some questions, Mr. Trask. Ma'am, I'm constrained by what the city code says. I would encourage you, however, as a resident of the city to come back before the city commission at one of its meetings, and you're welcome to explain my ruling and tell them how unfair it is if that's what you believe. It doesn't hurt my feelings at all. And if the city amends this ordinance and whatnot, and they can somehow grant you relief, they're the legislative body. All I can do is interpret what the city says. So, again, wish you the best of luck. And, please, Mr. Spataro, just work with Mr. Trask. I want you to make sure you have all the legal arguments that you want in that proposed order. I don't want you to have to waive anything or anything like that for purposes of appeal. And so if there's additional case law that you want to put in there, then feel free to do so. I do agree with Mr. Trask. I guess going back to the order, I don't find this to be a fine. I think I'm not reading it that way, but you can put that in there. Mr. Trask, do you have any questions about my findings or rulings that you need clarification on?
No, not so far, no, thank you.
All right, very good. Thank you all very much for coming today. Okay, that concludes the lengthy part of the agenda today. Does the city need to take a break, or are we ready to move into the code enforcement hearings?
I think we're ready to go.
Okay. All right. Thank you guys for sticking around. Welcome to the City of Madeira Beach Code Enforcement Hearing. My name is Bart Valdez. I'm the appointed special magistrate to hear today's cases. As you heard earlier, I'm a practicing attorney and been a member of the Florida Bar for over 25 years. I've been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today and you have not already been sworn in, then just a few moments you're going to need to stand and be sworn. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine, and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. All right, if you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, if there's anybody that walked in during our prior hearing and was not previously sworn and you want to talk to me today, please stand up and raise your right hand. Anybody? Looks like we got one more. Mr. Trask, go ahead and administer the oath, please.
You swear that the testimony you're about to give today is going to be the truth, the whole truth, and nothing but the truth? All right, thank you.
Okay, the first matter on the agenda is case number CE 25-137 for the property located at 913 Bay Point Drive. Is the city ready to proceed?
City's ready to proceed.
Go ahead, Mr. Trask.
City would call Holden Pinkard as its first witness. Mr. Pinkard, if you could state your occupation, your job responsibilities here at the city.
Building compliance supervisor, and some of my duties are issuing building code violations and city ordinance violations.
All right, are you familiar with this property at 913 Bay Point Drive?
Yes, I am.
Okay. Who owns that property, and how do you know that?
Bridget LaPointe, and that's through Pinellas County Property Appraiser.
Okay. In the agenda packet, I'm going to refer to a couple of different pages in the agenda packet, starting at page 80. Is that the printout from the Pinellas County Property Appraiser for this particular property that we're discussing now?
Yes.
Okay. Does this case come before code enforcement as a proactive code enforcement case, or was this complaint driven?
The city received a complaint
Okay. And what was the complaint the city received?
that there was a sailboat in the rear yard of the property.
Okay. And when that complaint was received, did someone from the city go out to the property to see whether or not there was a violation of a code provision here in the city?
Yes.
And who was the person that did that?
That was, I would say that was myself and Grace Mills at the time.
Okay. And Grace Mills was whom?
She was a code compliance officer. She's no longer with the city.
Okay. So when you went out to the property, what did you see?
I saw the sailboat that was up against the side and or rear of the property.
Okay. And why would that be a violation of the city code?
It would be storing of an abandoned vehicle and or boat.
Okay. Did you issue a courtesy notice of code violation for this violation on the property?
Yes, we did.
Okay. And what code section was cited as being they were in violation of?
It would be section 1469, specifically section 2, abandoned, inoperable, and unlicensed vehicles or boats.
All right. When you issued this first violation, this courtesy notice of code violation, and I'm referring to starting at page 85 of the agenda packet, what was the date that that was issued by the city?
The initial notice was mailed on October 7th of 2025.
And when the courtesy notice went out, did it go by regular mail, certified mail? How was it provided to the property owner?
The courtesy notice was sent regular mail.
All right. In that courtesy notice, did it ask the property owner to take corrective action?
Yes.
And what was the corrective action that the city was seeking?
To remove the sailboat from the property.
Okay. Do you know how the sailboat got in the backyard of this property?
My understanding is that the sailboat somehow got to the rear of that property due to the storms. So the hurricanes in September of 2024.
Okay. When this courtesy notice was sent, did you give the property owner some time to bring the property into compliance?
Yes, the follow-up date was 2 weeks from the date the initial letter was sent.
All right. Did the property owner, well, first of all, let me back up a second. When this letter was sent, was there anything attached to the letter?
If you're referring to the photograph that's included
Yes.
in the courtesy, yes, the photograph.
Okay, so let's turn to page 87 of the agenda packet, page 3 of 3 of the courtesy letter. Can you explain what's in this picture, this photograph?
So this is a street view looking at the property, and you can see the sailboat in the rear leaning against the property, and that would be the side/rear yard.
And what property are we talking about in the photograph? There are two homes. Are we talking about the photograph of the home that's to the left in the photograph?
Yes, the property to the left is the 913 Bay Point Drive.
Okay. Did the property owner bring the property into compliance within those 14 days that the city requested?
No.
Is the property in compliance as of today?
As of today, no.
All right. Did the city issue a notice of code violation?
Yes.
What date was that done?
That was sent on January 6th of 2026.
And when that notice of code violation was sent, did it cite the same code sections you had just testified to?
It did.
All right. And did you ask again for the property owner to take corrective action?
Yes.
Was it the same corrective action?
Yes.
Okay. This notice of code violation, was it sent by regular mail, certified mail? How was it sent?
The notice of violation was sent certified mail.
Okay. Did it attach the photograph that was attached to the courtesy notice, the same photograph?
Yes.
Okay. Is that reflective then on pages 88 through 90 of the agenda packet?
Yes.
Okay. Did the property owner get in contact with the city after the code violation notice was issued?
Yes, we did receive a response. I believe it was 2 separate responses. One is included in the packet.
All right, so starting on page 91, this is a letter that you received in response to the code violation notice?
Yes.
All right. This letter seems to be written by Bridget Lapointe. Did you have any conversations with her after this letter was received?
I believe after the first response letter that we received, we did have a brief discussion here at City Hall, and I believe shortly after that, the certified mail was sent, and we received the second response, which is the one we're looking at now, and I don't believe I've heard anything since.
Okay. If you could turn to page 93, what is this just the envelope that the letter came from, Mrs. Lapointe?
Yes.
Okay. All right. You've just testified the property is still not in compliance. Did the city go ahead then and issue a statement of violation, a notice of hearing, a request for hearing?
Yes.
All right. I want you to turn to page 96 of the packet. 96. Is this a statement of violation request for hearing that you had sent to the property owner?
Yes.
Okay. That's your signature on page 97?
Yes, it is.
All right. And did you also issue a notice of hearing for today's hearing?
Yes.
And is that shown on pages 98 and 99 of the packet?
Correct.
And when was the notice of hearing provided and the statement of violation provided to the property owner?
Both documents were provided on March 27th of 2026.
And how was that provided to the property owner?
Regular mail, certified mail, the property was posted, and the notice was also posted here at City Hall.
All right. I'd like you to turn to page 94, please. Did you prepare this affidavit of service reflecting that all of those attempts on service of the notice of hearing was sent?
Yes.
Regular mail, certified mail, posting at the property, and posting at City Hall?
Yes.
Okay. And did you also take photographs of the posting of the property and the posting at City Hall?
I did.
And are those reflected on pages 100 and 101?
Yes, they are.
Okay. How much time do you think that it would take to bring the property into compliance? Well, first of all, let's back up. How long has the boat been there?
I don't know exactly. I would guess at least since the storms of September 2024.
Okay. How much time do you think it'll take to get that boat off the property?
30 days?
Okay. If the property owner doesn't get it off the property within 30 days, what do you think a reasonable daily fine would be based upon what has occurred at the property?
It is hurricane season or quickly approaching, and I think it would be the $250 per day.
And that's because of the fact that you want it out of the property because of the hurricane season coming up?
Yes.
All right. You think it's a life safety issue in where it's at in the hurricane season?
Yes.
Okay. All right. I don't have any other questions for you. I would tender into evidence pages 80 through 101 of the agenda packet. And
All right, I'll go ahead and accept into evidence as exhibit number 1, pages 80 through 101 of the agenda packet. All right, is Bridget Lapointe here, or anybody on behalf of the property owner for the 913 Bay Point Drive? All right, who wants to come talk first and be the representative? All right, sir, give me your full name, please.
Audie Glenn Lewis,
Spell that for me.
AUDIEGLEN-LEWIS.
All right, and sir, what is your relationship to Ms. Lapointe or the property?
I'm a part owner, and I also am married to Miss Lapointe.
Okay, that
She is my
certainly
wife.
qualifies. All right, sir, this is your opportunity to ask questions or cross-examine Mr. Pinkert about his testimony. In just a few minutes, I'm going to give you an opportunity to tell me anything you want to tell me, call witnesses,
Okay.
provide documents or anything like that. But this is just your opportunity to cross-examine Mr. Pinkert. You don't have to cross-examine him, but if you have any questions about his testimony, this is your opportunity to ask him. So do you have any questions for Mr. Pinkert?
I have a lot of them.
All right, go ahead, sir. And again, remember, this is just questions right now. So you're going to have a chance to argue to me later, but this is just questions right now.
Okay. Let me, the first thing I do is, we've received those letters in the mail that you mailed out. I would disagree of that they were certified. Only one was certified, and it went to, not to our home address, but it went to a business address. But in those mailings, they specifically ask us to do something. And so I would hold up the one, this is the one from October 7th.
I'd object. This is time for cross-examination, and he's making statements.
No, it's not.
Go ahead, sir. Just go ahead and ask Mr. Pinkert whatever
That's what
questions
I'm
you want
gonna
to
do,
ask.
okay.
Okay, go ahead.
So, Mr. Pinkert, in this October 7th mailing, it says corrective actions. It gives two. It says sailboat must be removed from the property, and please reply with a plan of corrections before the follow-up date listed. The follow-up date was October 21st of 2025. So did you receive a follow-up response?
I received a follow-up response. I would have to check on the date because the initial response letter wasn't included with this packet.
Oh, okay. So you're saying it wasn't included. So then, so my wife didn't show up at City Hall on the 20th of October, 25. She didn't show up there at the City Hall and demand that you guys sign for the packet?
Demand that she,
Yeah, she brought a packet in to address what you told us to do. You told us corrective action had to be the sailboat removed from the property, and please reply with a plan of correction before the follow-up date listed, which was October 21st by your own letter. And our response would have been given to you and signed by city staff on October 20th of 2025. So, and in fact, didn't you meet with my beautiful wife there?
Okay, hold on a second. Hold on.
Okay.
We're going to follow a very specific format for this
Okay.
hearing, okay? And it works, and it's what this code requires.
Okay.
This is your opportunity to ask questions of Mr. Pinkert.
That's what I'm doing. I'm asking
I
questions.
know, but then Ms. Lapointe wants to speak, and I want you to know,
okay,
you
no.
have a chance for her to speak. You guys are going to have
Absolutely.
all the due process in the world. But in order for this hearing to work and for it to make sense, this needs to be questions of Mr. Pinkard.
Yeah, that's
okay?
what I'm doing. That's exactly
Okay,
what I'm doing. I'm
but
asking
when
you-
I see Ms. Lapointe start standing up and
Well, I
asking.
think she misinterpreted. When I said, did he meet with her?
Fair enough.
She decided to say.
Okay, so let's just keep with questions at this point.
Okay. So, did you meet with my wife that day when she brought the packet in?
I don't recall the date, but she did come into City Hall, and I did have a conversation with her. Yes.
Okay. All right. And we can provide that later if you want, but we do have signatures of staff accepting the plan. So we did submit a plan on this one. Now, to the second one, the one that was dated in January, we also responded to that one and responded to it. Well, it was impossible to respond to it exactly the way they said, because all they did was change the date on the first letter. They changed it to a January date, and then they sent the same exact letter requesting response by October 21st of 2025, even though it was a 2026 request. And it did not come by certified mail. It came by regular mail. Not that that matters too much, but it did. And we responded to that one as well. We actually put into it, we responded to it, and then we put in the plan of action again, the same plan of action. Actually, we copied it exactly the way it was, and we sent it back. So did you receive that one? The plan of action from us stating that that you guys were going into history, but we sent it to you. We gave you a plan of action, a very specific plan of action.
I received the second response, yes.
Okay. Now, I want to ask, did anybody, after receiving those two plans of actions from us, which is what you asked for, you said, sailboat must be removed from property. Please reply with a plan of corrections before the follow-up date listed. And we did it both times. We provided that with you. So my question is, did anybody from city staff respond back to us with what they were going to do to comply with the plan of action that was sent forward? Did you or anyone else on your staff or anybody else do that?
No.
Okay, so basically, we don't have an argument that we waited too long. We actually met every date, and we submitted what they requested us to submit, and we submitted them on time. Even though the first one required us to do it, we didn't actually receive that letter because it went to the office first, not our home address. It went there first, and the staff over there forwarded it to us. So we actually received it on the 19th of October. And we responded to it, and we did it hand carry with them resigning for it because there was no other way to get it to them on time. We couldn't even send a FedEx with a guarantee for that.
Sir, let me, and again, I don't want to cut you off, but I want you to understand this portion of the hearing is for questions.
I know. I'm getting to that.
But let me explain to you. I've read your letter. I think I understand your position. Your position is, if I understand it correctly, this boat washed up, the fire department or somebody put it in your backyard, the city needs to take steps to remove it. Am I summarizing your position fairly at this point?
Well, that's a little understated, but yeah, we don't own a boat. We didn't own the boat. It's not our boat, somebody else's boat. And somebody took it into their own hands to change the circumstances.
I think
of
I'm
that boat.
following you there. I'm following you based
We
on.
weren't even here. We were in Europe.
Understood.
So,
and if I understand what you're saying earlier, if I understand the purpose of this cross-examination, it's to say to the city that you were proactive, you took steps to provide a plan of what you
We
perceive
did
to be
provide a plan, a very good plan.
Okay, so you see, sir, I'm following your arguments here.
Okay,
But
all right.
what I'd like you to do is ask whatever additional questions you want to ask of Mr. Pinkard so we can get on to the real meat of this, is you telling me what you
Okay.
want to tell me.
So,
Any more questions?
yeah, I'm just asking the question. Because we had sent these plans of actions in there as you requested both times, is there a reason that staff, nobody responded back to us with how to do it? Do they need to schedule it, to do anything? What was the reason that we never heard back from staff?
I'm not sure. I received the if by plan of action you're referring to the document that's on the screen, I didn't take that as a plan of action.
Oh, okay. So even though it has detailed steps in the plan of action, none of that was considered a plan of action by you? Okay. And then on the third one, you sent us a third one recently, and in that statement, you said that you posted it on our house. You said you posted it on our house. You also posted it here. You said you sent it by certified mail. Certified mail, we can definitely know it happened because the same staff forwarded that certified mail envelope to us, and they took a picture of it because it was so late in coming. They took a picture of it to send to our camera. Unfortunately, they didn't take a picture of the back pages of what he mailed. The staff didn't realize that there was stuff on the back, so we got the front pages of the certified mailing as pictures, which we have on our phone, which if you want to see them. So we didn't get the other detail. So my question is to you, I'm wondering where you posted it on our house. You said you did it on the 27th of October. If you've been out to the house, you probably know that we have cameras everywhere. There's not a single part of that house that doesn't have camera coverage, including the doorbell. So with that camera coverage, my problem was when I went back to look at the cameras, I found no indication that anybody, we were actually gone that day too, the day you claimed, 27th. We actually were in Missouri. We flew to go to a 50th wedding anniversary with my brother and his wife. So we weren't here. We actually left at 3 o'clock in the morning that day, so we wouldn't have seen you ourselves for sure. But we did check the cameras, and we've seen no evidence that you were at the property or that you or anybody else was then or since. So we're wondering if you can explain that to us, how you could come and post it, the posting not be there presently, and how our cameras don't have, because they definitely record for longer than the amount of time that, since we could still pull them up today if they were there. So can you explain that to me?
Sure. I didn't personally post it. Taylor Davis and Connor Mego to my right did, and that's why we take the timestamp of the posting.
Okay.
And that's
so
included in the packet.
So where was it posted on our house, and how did you escape camera view?
No, sir, there's evidence right here. This is the picture he's talking about. It was posted on March 27th, 2026. And I don't want to cut you off, but these really aren't relevant questions for me because you're here today, you got notice of this. So unless you're going to make an argument that you haven't had proper notice, which is hard when both you and your wife are showing up here, for me to understand how you didn't have notice of today's proceeding. That's the real purpose of what he's saying.
Well,
let me finish, sir.
Okay.
It's to show that you got notice so you could be here today.
Okay.
So
again,
I just don't know if I find these relevant, but again, I sense you really want to tell me a lot. But this is not the time to do that.
Okay.
Why don't you go ahead and, I'm going to give you a chance to ask maybe 2 more questions of Mr. Pinkard, unless you have other relevant questions, and then let's get on to where you and your wife can tell me about your
All right.
stuff.
So since he transferred it to his colleague, I'll just ask the same question, which is, how did you post it? Where did you post it? And how did you do it without us having it picked up by camera?
So she is not testifying at this point.
Okay, I'm going to sustain the objection because, again, this is for notice. So do you have any other questions of Mr. Pinkard about this violation?
No, let me just ask.
Of course.
Do you have anything?
Okay.
Okay. All right. So I think we've asked enough questions.
All right. Thank you, sir. Mr. Trask, is there any other witnesses you want to call on this
Yes.
one?
Yes,
All
I
right, go
called John Mordelite. John, if you can step forward. And why don't you go ahead and sit right here at this microphone, turn that on.
And sir, if you can just please spell your last name for me.
Last name spelling Mortellite.
All right, sir. Go ahead, Mr. Trask.
All right, so you were sworn in earlier? Yes. You're going to need to speak up so everybody can hear you. Okay.
Yes.
Okay. So what is your occupation here at the city and what are your job responsibilities?
I am the deputy chief of the fire department. I am responsible for the daily operations and training of our personnel.
Okay. How long have you been working for the city of Madeira Beach in the fire department?
For the city of Madeira Beach, a little over 2 years.
Okay. And before that, were you working at another fire department with the similar responsibilities?
Yes, sir. I was the deputy fire chief of Pinellas Suncoast, retired there with 30 years of service.
Okay. Are you familiar with this property that we're talking about today?
Yes.
Okay. Did you prepare an incident report which is dated 9/26/2024, but it was prepared by you on October 28, 2025?
Yes.
Okay. Can you explain the reason why you prepared an incident report with regard to this particular property?
I was asked to do this by the fire chief pertaining to a complaint that was made.
Okay. And when you prepared this report, first of all, were you present on September 26, 2024, when this activity occurred that's being talked about in the report?
Not at the residence, no.
Okay. Who was present at this resident on that date?
Lieutenant Wazalewski and Eric Ublis.
Okay. And are both of those firefighters with the fire department?
Yes.
Okay. And did you interview both of those individuals to prepare this report?
I did.
Okay. And can you explain to me what happened on September 26, 2024 at this property at 913 Bay Point Drive that required the preparation of this incident report?
Yeah, we were operating in storm mode at the time due to the oncoming storm. We received a call for service out there to the location with a report of a sailboat adrift near and on the property. We were operating in reduced service due to the storm weather and conditions. At the time, tidal waters had already exceeded the seawall and were encroaching into residential areas. The initial apparatus that was sent out there could not reach the location due to the water depth, so our high water vehicle was deployed to access the area safely. Upon arrival, the two persons on that apparatus located the vessel in the rear yard of the reported address. Sailboat was found listing and close to the proximity of the residence, presenting a risk of structural contact and damage. Our personnel conducted a thorough search of the vessel to check for occupants and victims. No persons were located on or around the vessel, and the owner of the vessel was not on scene or immediately identifiable. During operations, neighbors at the scene approached the personnel to insist that the vessel be removed from the property. However, fire department personnel explained that given the ongoing storm conditions, safety concerns, removal of that vessel was not a viable option at the time. Our department's priority is to ensure life safety and prevent further property damage. The crews mitigated any additional damage to both the vessel and the residence by securing the sailboat in its current position using the vessel's existing ropes, some straps found on board, and the anchor. These measures were taken to stabilize the boat and prevent it from drifting further or impacting any structures. It was reported to me that there were no injuries, no additional hazards were identified at the time of the operation, and the scene was left secured, and no further fire department action was required.
Okay, so the sailboat that we're seeing in the photograph that is on the screen today was in that location when the fire department arrived. Is that correct?
To the best of my knowledge.
And that's where the boat was tied off so that it wouldn't damage either one of the homes to the left or the right. Is that accurate?
Correct.
Okay. Do you know who owns this vessel?
I do not.
Okay. When you prepared this report, you said it was prepared as a direct result of the fire chief asking for it to be prepared?
Correct.
Okay. And do you have a copy of it today where we could submit it into evidence for the special magistrate?
Yes, sir.
Okay. Is there anything else that you wanted to mention that maybe was not in the report that you think is important for the special magistrate to know about this sailboat in this backyard?
I cannot think of any.
All right, thank you. I would tender into evidence the report dated September 26, 2024, prepared by this witness.
All right, I'll go ahead and accept in evidence as exhibit number 2, the incident report prepared by Mr. Mortaletti. Thank you. Anything else of this witness, Mr. Trask?
No, sir. Don't go.
Okay. just like you did with Mr. Pinker, do you have any questions you want to ask of Deputy Chief Mortaletti?
Thank you. First off, I want to say, being a retired Army officer myself, I have nothing but the highest regard for any first responders, and Deputy Chief included. Love them, worked with them many times myself, and I was a logistics officer, so I want to say that up front. Thank you for service, and we do appreciate it. Now, on the day of this occurrence, I know you said you were not present, but you've interviewed the lieutenant and the other fireman that was there on that day. What I'm not hearing is that this boat was still in the water. It was not on our land, it was in the water. And we had 10 or 12 neighbors send us pictures and videos of this whole event, including those trucks, those high waiting trucks. I had one neighbor sent me all the pictures of them. They were parked in our driveway. Can you, from your interviews with those other two firemen, tell us approximately where this boat was out in the water and how far away it is from this current resting position?
If I understand your question, it's two parts there. I cannot say for sure where it was based on where it is. I have not been out to the location, so I don't know where it is right now.
All right.
So I can't tell you whether it has moved since they attempted to secure it in location. But it was my understanding from my interview with them that it had already breached over the seawall.
Okay.
On or inside of your yard. It was not floating upright.
Okay. And the anchoring, I heard you say rope and anchor off the vessel. Did they mention two ropes and an anchor off the vessel?
I do not recall exactly the number of ropes. I do remember them saying that they used ropes, a strap, a ratchet strap that they used, as well as the anchor system.
Okay. The ratchet strap is new to me, so I'm not sure of that. But anyway, so I understand. Did you guys have any contact, you or those officers, with the Sheriff's Department and their involvement with this vessel, this abandoned vessel? This is not our, just so everybody's clear, this is not our boat, so.
I cannot speak for them. I did not ask them whether or not they had any involvement with the Sheriff's Office. The only hearing of what's going on from the Sheriff's Office, that it was still there, that's the only involvement that I've had with the Sheriff's Office.
Okay, so you weren't the one that notified the Sheriff's Office that it was now aground and that it no longer presented a hazard to the neighborhood or the houses or anything?
The crew that responded out there made that notification to our dispatch when they were.
To your dispatch?
Correct.
Is that something that's connected to Pinellas County Sheriff's Department or the Marine Unit or any of that?
We share a dispatch center.
Oh, you share, so they would be listening in?
They should have received that information.
Okay.
Or could have.
So in your conversations with these two firemen, Chief, did they never said anything about this boat being tagged multiple times since August 2nd by the Marine Sheriff's Division and them tracking the owner, Richard, don't quote me, it's something like Richard Texeria?
No, there would have been no information prior to us going out there.
Okay, so on the day you went, it was just the distress call where they thought maybe somebody, because I talked to the neighbor that called that, he called it a 911 call. I think they originally thought somebody was on the vessel, right?
I don't know whether or not we got word that there was or was not anybody on the vessel. I do know that it came in from a 911 call.
Okay, all right. Honey, do you have anything else you want to ask? This is asking him. Oh, okay.
The only question that I would have to ask him is that if he wasn't present at the location of the incident, why is he the one here today? Because he's he can't answer all those questions because he wasn't there. Why is he the one here to represent the fire department if he wasn't present the day of the incident?
I don't understand what the question exactly is.
Why are you the person here answering for the fire department if you were not present at the incident location?
I'm responsible for our personnel, and I did the interview of those individuals to bring that information here.
I just have one follow-up question, and it's because we had obtained a very extensive report that we got through public records request through the sheriff's office a while back. And one of the things they mentioned there, which I don't know how fire departments operate, so I don't know if this is true of you, but they kept mentioning uploading photographs to their database, and for every time they would have an interaction with this abandoned boat issue, and they're tagging it and all that stuff. Did you guys have uploaded? Is that normal for?
No, sir.
For fire, so you wouldn't upload?
Not for us. No, we do. The sheriff's office carries body cameras. We do not.
Okay. Am I allowed to show him some of these pictures that we've got that are his fire department there?
Just show Mr. Trask first if you want to ask him questions about those pictures.
Okay.
Okay.
Yeah, I just want to bring your attention to the location of the boat. It's obviously in water. It's not in our yard. It's at that time.
I'd object. I mean, if he has specific questions, does he know where these photographs were taken, who took them, what the day was? If you have specific questions, I think that's appropriate. But otherwise, sending him or showing these photographs and making statements, that's not cross-examination.
Okay, well, I thought it was apparent on the photographs that they're from the 26th.
Let me roll in the objection. The objection sustained. If you have any specific questions you want to ask this witness about those, you can do so, subject to Mr. Trask's objections. And again, sir, I want you to know, it may be more effective for you, instead of asking him questions, for you to tell me whatever you want to tell me about.
Okay, I'm just,
photographs.
well, I got the opportunity for the guy that interviewed them. We weren't here. We were.
Fair enough. So
we were
again, if
not
you
here.
want to ask him questions, please feel free to ask him questions. But also understand this, I'm going to give you an opportunity to show me those photos and tell me whatever you believe those
All
photos.
right, this is the first time. Well, actually, I was in here once for a variance to an ordinance when we were building the house.
Fair enough. So do you have
But that's it.
Fair enough. Do you have any questions for this witness specifically about those photographs?
I was just wondering if that looks like the lieutenant and the, I know those photos are bad, believe me. It shows, they look like similar uniforms to what you're wearing, but, I don't know. It's
I
two
honestly,
people
I can't.
and,
I do see two people, but I can't tell you.
yeah,
who
and
they
I
are.
actually had, we didn't print them out, but we had pictures of the, I call them duck vehicles, those high water vehicles you can use to get into an area that's too big. Anyway, so it doesn't trigger anything else for you with your conversations with the lieutenant and the other.
Object to the form of the question.
All right, I'll sustain that objection. Anything else for this witness that you want to ask specifically about those questions?
No,
or
I
those
think that's
photographs?
great. I appreciate it.
All
Thank
right.
you so much for your service.
All right.
We'll see you. You're good.
Mr. Trask, who else would the city like to call on this?
No other witnesses for this case.
Okay. All right. It is your opportunity, sir, to come forward and tell me anything you want to tell me, call any witnesses you want to call, provide any documents, evidence, anything you want to provide to me. This is your opportunity to present to me your case.
You want these first?
Just anything you want to show to me, just I ask you to show to Mr. Trask first.
He's just saw him in the back.
Okay, Mr. Trask, you have any objection to
No, I don't have any
this
questions.
witness showing me these photographs?
No.
All right. Now, sir, let me ask you, are these for me to keep and put into the record here today?
Yes.
All right, great. We'll go ahead and I'm going to mark these as exhibit number 3 to today's proceeding. All All right, sir, go ahead and tell me what you want to tell me about these photographs or anything else you want to tell me about this particular code violation.
All righty. So we did respond to each one of those things. I have here a copy of the signature from staff. Holden Pinkard is the one that signed for it on 10/20/25. Do you want a copy of this now, or should I be taking it to Mr. Trask first?
Just show to Mr. Trask, and if he has no objection, I'll take a look at it. If he does have an objection, I'll evaluate that objection.
I start with that because it shows clearly that we did comply on time.
All right.
Okay. I don't have any objections to this.
Okay, we'll go ahead and mark this as exhibit number 4 to today's proceeding.
All right. So we were asked in the letter that was sent to us, the warning order or whatever they want to call it, or whatever it was called, to remove the boat and give them a plan of action and timeline for doing that. So our corrective action, which is what they asked us for, was A, we demand that the responsible party, the city of Madera Beach, hereafter city, remove the abandoned boat that they caused to be stored on our property immediately or within a reasonable time frame, and to do so at their expense and without causing additional harm to our house, property, seawall, or landscape. Those pictures that we show, they show that when they came over here, that they anchored it to our palm tree. It shows 3 ropes going off of it if you look at the pictures. There was a rope on the side, a rope in the front, and a chain off the front. The rope off the side went to actually to the things that's one of the support beams that goes up the house, which that broke off at some point because we found the residual rope from it breaking loose. And we also have the residual rope from the rope that was attached to the palm tree in our yard. It's still there. We didn't move it. And then the anchor was wrapped around the palm tree, and you can see in those pictures that the bolt was originally a lot further up. It was actually close to our other neighbors, to our left's boat, near there. And that's where they tied off the chain. The firemen would have done that originally. So it was in the water, and it was not in our property. Matter of fact, it's quite a bit further down where you see the evidence of when it crossed over during the hurricane itself. And that chain that was there straight into the water, which is what they hooked it to, it was in the water, and they just went straight from the boat to the palm tree. It later became, during the storm, it became something that wrapped around our other palm tree. It cut into it because the other palm tree sets out further than that one does toward the water. And when the chain and the boat was being pushed down a thing, it actually cut like a 3-inch chain. The chain cut into the tree about 2 or 3 inches. And so it's actually part of the tree now. And its position on our property is still taut. The chain shows itself as, it's not a loose chain like it shows in those photos you're looking at. It's not a loose chain. It's a taut chain wrapped through our second tree and then to the end location, which is as far as the boat could get, because it was chained to our property. And so, it's not leaning against, which Holden said, it is actually slammed against our house. It put luckily it was a concrete filled pillar all the way down to the footing that it slammed into. So it took out about a 3-inch chunk of the concrete, and it's listed probably 30-40% this way against the house. And it's a large boat. This is not a, I've never owned a boat. My wife, we don't own boats. We don't even have a dock. So we're not boat people. We love looking at them in the water, watching people go by. That's great. But I don't want to work on them. I'm not a fisherman. I don't have any real interest. Now, I like big boats. We like to go out on cruises. That's more our taste. So this boat is actually 42 feet long. It's over 4 stories high with the mast. It's leaning against our house at a serious tilt, wedged up against it in the concrete. But the mast, we have a 3-story house, and the mast is way above the 3rd story. That's why I say it's probably a 4-story mast, and that's with it leaning. So that boat has been sitting there since this happened. What's problematic about that boat is that owner, Richard Texeria, and we've actually got copies, if you want them, from the Sheriff's Department, detailing all the detail prior to September 26th that the fireman said. That boat was abandoned and was floating around several places in the area and kept getting tagged by the Sheriff's Department. They kept having conversation with them to remove it, or they were going to send it to salvage. That all the way back to August 2nd. So long before the hurricanes came, there was, that boat was known to be a problem, and it didn't show up in our yard, or behind our yard, I should say, until the 26th. So, but it had been all over the place prior to that, and they listed it as an abandoned vehicle, and they kept warning the owner that he had to take it out of the water. Nothing happened. So from our perspective, as people who never owned a boat, don't have a dock, we look at it as somebody took advantage of, and here's the real crux of it. We've spent over a year battling the insurance company on they wanted to lowball us, and I'm sure, and at least we're lucky, we're one of the few in our neighborhood that had a hurricane-ready house. We had electricity up high on the 1st floor, and we had lots of protection. We have the high-grade windows, all stuff, because our house was completed in 2017. So, matter of fact, Frank DeSantis, who works for the city, he was a great help to us when we were building it. Great inspector, and he did, he came out there, and I probably bugged him more than anybody in the world. I used to send him emails all the time, anything, because I was owner-operator. I was owner-builder. My wife and I were down as owner-builders. We had lots of contractors come in and help, but we controlled it because we wanted quality in that house. And I'm glad we did, because, we didn't suffer the same fates other people did in our neighborhood. Especially, we got friends and neighbors that have 1-story houses that are still not back in their houses, still waiting on work. One neighbor actually tore their house down already right across the street from us. And so it's an ongoing thing. We recognize that. I don't want to dismiss that, because that's, our problem isn't remotely as big as theirs. But it's not our boat. It wasn't our decision to tie that boat and anchor it to our yard. We don't, and we actually keep responding to these things. The city, the last response, when we couldn't get them to, they've not been answering at all anything that we've sent them, even though we gave them very specific things we wanted done. We wanted them to take responsibility for the fact that they put the boat in our yard, and they kept telling us we were storing a boat. Well, we have no boat to store, and we never stored a boat in our life. So we take issue with that they're telling us they're going to charge us $250. This latest one said up to $500 a day for non-compliance and keeping the boat there when it ain't our boat and we never put it there. So it sounds ridiculous to us that they would. Matter of fact, it was so ridiculous sounding to us, we were wondering what the motivation behind it was. We were seriously wondering I feared that My wife's black. That was part of the motivation. Maybe they just thought, well, you know what, we can pick on her. She's about the only one in town, so we can pick on her. Because I'm trying to find out what the motivation is. Because to me, if you were the person who did something, why are you coming to me to undo it? If I didn't put the boat there, I understand the fire department had to make a decision, but it complicated our insurance. For instance, when we filed our claim, we filed a claim, waited for them to answer. They came back with a bad answer. We hired a public adjuster and then subsequently an attorney to follow through. We finally got resolution out of it over a year, right? But one of the things that was very apparent early on, when even our public adjuster that we hired, he told me early on that they couldn't take any responsibility for the sailboat or the seawall because there was human intervention. So there was, in other words, the hurricane didn't put that boat there. It's clear by what they can see and take pictures of that somebody intervened. So that chain, that taut chain there, laying up with the boat up against our house means that somebody did that. It wasn't God. It's not a God act. God, and clearly the boat, the direction of the travel of the boat with the chain, it wouldn't have hit our house because the boat, we know for sure that it wasn't at the end of where it was going because it's got even today you can go out there, the chain is completely, you could swing off of it. It's that tight.
Yeah, I understand. I fully understand your argument, sir. It's not your boat. You didn't put it there. It's your position that the fire department did something to cause that boat to be on your property.
And Pinellas County, that's why we put it in there. When we sent our letter of our corrective action, we put it together specifically to deal with the fact that it wasn't our problem, wasn't our decision, wasn't anything. And in my mind, whoever made that decision, the city officials, and including contracted policing, which is what you guys have here. They have here. I think they've got Pinellas County Sheriff's Department working as contracted policing outside of their role of Pinellas County Sheriffs, which they also have that role. So they had a role to play, the fire department had a role to play, and then of course Holden had a role to play that responding back. And what we get is you didn't respond, you didn't do anything when we did. We think it's a very normal process that the responsible party is the one who deals with it. And as an example, I mean, I can imagine, and I got the greatest respect for the fire department and the sheriff's department. You know, I've been retired 29 years in the military. Anybody wearing a uniform, I've got a lot of respect for. But what I don't understand is why we are being penalized for something we did not do, we're not present or anything. And then I sent in another request to the city on the second time they did it because they weren't responding to requests. We put the same action plan in the second letter. And then in that letter, I included that a public records request to get the conversation going on inside the thing. Well, they did one thing really good. They sent us an invoice request. And I about fell out of my chair when I read it. $16,700 they wanted us to pay by bank wire transfer to pay for them giving us the information that proves that they did it. So,
and sir, I think you're repeating yourself, so I fully understand what your argument is. Mr. Trask, do you have any questions of this witness?
I have a few questions, if he's done.
All right. Anything else you want to tell me before I turn it over to Mr.
Trask? I think we should be giving you some stuff because it sounds like to me that
please
you don't
give
have
me
all the letters because do you have more than one letter?
I have what the city provided, which is pages 80 through 101 of the agenda package, and then I have the two exhibits or the 2-page incident report. I have your photographs and I have your letter. Again, I'm happy to accept anything you want to show me today. All I do is ask you to show Mr. Trask first.
Okay. Another factor here that I'm looking at my notes here for this meeting is that it actually said in the part that we never got, there was no notice on our house. We didn't get that one. But the one that was sent to us by text message, a photo of the thing, it didn't show the requirement to have 5 days participation to call in extra witnesses and stuff. I actually went scrambling around my neighborhood trying to, on the day before Good Friday, which is when we found out, trying to get people engaged to come here today. And half the people are gone, visiting family, out of state. One of them's out of the country in the Panama Canal on a cruise. So a lot of these key players that sent us photos, sent us videos, aren't here. And so I'm gonna, oh, you got ones of all these? Okay. Okay. All right. Okay. Did you make a copy? Did you make a copy of this?
Yes, I did.
Okay. I'm asking my wife for the proof that we also complied with this one in time by our certified receipt. The second one that came in, we went down and we had enough time to mail it by return receipt requested and certified receipt, so we did that. I'm asking my wife to give me the copy of it.
Here, also the report from the Pinellas County Sheriff.
Oh, yeah,
You need to have as evidence.
right. Oh, there's the copy of the receipt.
You want a copy of that?
We're agreeing it was certified, so I don't think we need a copy of that. So what I've got here is I've got case master reports from the Pinellas County Sheriff's Offices for that boat and the incidents related to the boat. And I also got a copy of the return receipt requested thing that was met. And then I'm giving, and honey, you know what else is missing here is this, did you give me the latest one we just sent?
Here's the invoice. $60,000 invoice.
Okay, that's that. Am I missing anything else? Make sure I'm not leaving out anything you guys need. Now, the one thing, and I know you're a lawyer, 25 years with the Florida law, so you know this thing already. But what I provided them as a operation, as a plan, a corrective plan, would, I know in my years of being an officer and submitting stuff all the time, especially I was an environmental officer as well, so I dealt with tons of this kind of stuff all the time. Very hard to deal with stuff. My plan would have met anything that I had. It names who's responsible and gives them a way to fix it. So we haven't delayed any. We don't have any time under our belt where we've missed a thing. So I'm going to show this. Mispronounce your name, sorry.
Oh, it's okay.
And we're not problem people. We're not. You know, if you talk to Frank DeSantis, who used to be at the city, he used to tell me all the time, he said, Audie, you're my favorite house to visit. He'd say, you know, everybody else, he said, the code requires one or two things. You guys always do 3 or 4. He goes, I never worry about you guys doing what you're supposed to do. You always do it with it, even in this turbulent time that we're in. He helped us build a very nice hurricane ready and you know, compared to others, we are really well done, sir. But I do regret that we lost a BMW with 44,000 original miles. And, you know, that hurt. It was a very nice BMW.
I just need to ask my client this. Okay, so if I can respond to a couple of the documents. The city has no objection to the letter that Ms. LaPointe sent on October 19th. The letter January 14th, which is already in the packet. I don't have any objection if he wants to put another copy in. The receipt from the post office, I don't have any objection to that being received in evidence. I'll bring them down in just a moment. I just want to talk to you about these other ones.
Okay.
There is an incident report from the sheriff's office for activity that was occurring back in August 2024 about the boat. To me, I'm objecting on the basis of relevance. It's not relevant to what's happening today. So I'd object on that.
Hold on, let him
Okay,
finish his
okay.
objection, get everything on the record, then
right.
I'll rule, or then I'll hear from you and then rule.
Mr. Pinker will testify, as I was just going over, the invoice is a phishing scam. This is not from the city of Madeira Beach.
It's who?
It's a
It's a
phishing.
cyber scam. They're trying to scam me out of money. It's not something the city actually sent.
You're saying that invoice we received didn't come from the city?
This did not come from the city of Madeira Beach.
Okay.
Good thing you didn't.
Wow.
And then the two emails that were sent by Ms. LaPointe to the company that was fishing for money, I would object to that too, since the city did not receive those, and Mr. Pinker will testify to that if need be. So objecting to
Okay.
this, objecting to the reports, no objection to the letters and the postage receipt.
All right.
Okay. Wow.
All right, let me sort through this just for 1 second. So,
No objection to those.
all right, so I'm going to go ahead and accept as exhibit number 5 the documents Mr. Travis identified that were not objected to. Okay, now,
The two police reports.
okay, then you object to both of these? Let me just take- Okay. All right. All right, I'm going to go ahead and accept into evidence as exhibit number 6, the police reports. And the reason why is they do reference the vessel being on the property in this.
Yes, sir. They actually closed out the case because they said it was above waterline and clearly not a danger to other boats or other things anymore, being anchored the way it is against our house. And I don't know if it's pertinent or not to you or not, sir, but I actually tried to get the boat, the sailboat, into the initial thing with the, I didn't know at that time, my neighbors hadn't come out of the woodwork telling me all this stuff they told me. I've had 10 or 12 neighbors send me pictures and videos of the stuff going on, and we know all of them. So the people we know, they sent us pictures. We only gave you a handful, but we got a lot. I mean, I got every one of those pictures of those big trucks that the firemen used, and we got all that stuff. But I purposely I put it into my original submittal to the insurance company. I did not know at the time. Obviously, to me, it was debris in the yard, and if anything else. But because it was chained and tied and all that, I couldn't get in. I tried hard. I had my own attorney helping me, and nobody would, and even the umpires ended up coming into the case later. Nobody would agree that the sailboat was their responsibility or the seawall damage was their responsibility because of the intervention.
All right, let me just thank you, sir, for that. If this is all a scam and a fraud, and I have no reason to believe it's not, I'm going to go ahead and let you, the city can explain this to you, but I'm not going to accept that into evidence because I don't think it's relevant of any point that I'm considering today. But everything else I'll accept into evidence. All right.
Okay, well, then we will apologize officially to the city for blaming them for sending us a $16,700 invoice. That they didn't send. We didn't.
Well, it's a good thing you didn't pay it, sir. All right. Anything else you want to tell me about this particular violation before Mr. Trask has some questions for you?
I don't want to ignore.
All right. Well, you finish first, and then I'll let her come up and tell me anything you want. So anything you want to tell me individually?
I think I'm good.
Okay. Then sit tight. Mr. Trask, do you have some questions for this witness?
Mr. Lewis, I have a few questions for you, sir.
Okay, sorry.
Okay. All right, so we've established that the boat has been in your backyard since September 2024, correct?
Yeah, it's been there since the hurricanes,
Okay.
the 2 back-to-back hurricanes.
All right. Have you done anything to that sailboat? Have you modified it in any way?
Modified it? In what way would I modify it? I'm not a boat person, so I know nothing about boats. I have my knowledge. I could write on a matchbook, and you could read it in a second or two. No, I don't own boats. I don't mess with boats. The only thing I will say we did, which is in the letters already, is when Trump got reelected or elected, whatever you want to call it. I don't know if it's reelection or election, but when he got elected, my brother and I had the idea to scrape off the barnacles because it was a pretty ugly boat. It used to be full of barnacles, and it was already pretty bad. We decided to take the barnacles off and paint it red, white, and blue, that bottom portion that's normally under the water line. And we put on there something that means a lot to my wife and I. In our service, the military and all that is prayer warriors unite, fight, 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 praying for our president, Donald J. Trump. Now, I can tell you that stuff, I've had to re-glue those letters in the time that boat's been sitting on there while we've been waiting on the city. I've had to re-glue those letters on there probably 20 times because they keep falling off and I go out there in the yard and look, and if a letter's off, I put some glue back on it, stick it back where it was. I've been doing that since then, and we even put Christmas lights on it at Christmas time. But other than that, no, I don't have any. My brother Ray climbed up in the boat to find out how big it was. He found the registration inside of it. He climbed inside of it, looked for the registration of the boat.
I think you've answered my question. So you've painted the boat and.
No, we painted the boat is too far. We painted the underbelly of the boat, which had barnacles on it before.
Okay, you painted a portion of the boat.
Yeah, a portion of the boat.
Okay.
With, that had, barnacles, and we removed the barnacles and scraped them off and painted that bottom portion of the boat.
What else have you done to the boat?
What else have I done to the boat?
Yes, sir.
Other than put lights on it and take pictures of it?
Okay.
Nothing.
All right. Have you attempted to remove the boat from your backyard?
The only thing I did was during the time of the high hurricane stuff, when everybody and their brother was going out soliciting, ringing your doorbell and all that kind of stuff. It was happening all the time right after the hurricanes. We didn't even get back into town until November 12th.
Okay.
So we have people that have our code and go check on stuff, including our landscaper. And so
I don't need to know any of that. My question to you was, have you done anything to have the boat removed from your?
The only thing I did was I took 2 quotes from, no, I guess there was 3 things I did. I took 2 quotes from people that came by specifically to ask me if I needed somebody to pull the boat out of my backyard. Both people told me the same thing, except they were $5,000 off. The first person told me it would take $20,000 to put a crane in the water. It has to be in the water, they told me, because the power lines and everything else going forward, you can't do it because it's obviously too tall of a boat. So I had one quote me $20,000. These are verbal quotes. I didn't get anything from them but a verbal quote. One guy told me $20,000 he could remove the boat. He'd lift it out of the backyard and put it back in the water and tow it away. And another one quoted me $25,000. That was almost a week later, maybe 10 days. It wasn't very long from the first guy. And then I also had, my brother was visiting me one time. This was later last year, from Missouri. He owns a huge salvage business in Bloomsdale, Missouri. And he came down and looked at the boat to see if the easier thing might be just to land salvage it and carry it off on a flatbed. Cut it up into pieces, he said, with some kind of a special torch. He said it could be cut up, and he said it's an aluminum boat, and he said it's high-grade aluminum, so it could be cut up and carried off for salvage.
All right.
So
you've answered my question.
Okay, that's the only 3 things I've done other than, giving the city my plan of action, because I think they owned it. They touched it. They owned it. They kept me from getting it paid for, the insurance company, so.
Well, your plan of action was demanding the city to go out to your property and remove the boat, demanding the city pay for all costs of fixing your seawall, demanding that the city repair and replace all your landscaping.
No, not all the landscaping, just the landscaping affected by the boat coming on shore.
Threatening the city with costs and damages, and that you're threatening to assemble a comprehensive legal team against the city. So that was your plan of action. Did I get that all correct?
No, the plan of action doesn't include that. The rest of the letter does. So yes, if we didn't get the city to do what the city should be doing, we were going to go after. We even talked about going to the DHS and getting their help. Because if you're going to remove sovereign immunity from a municipality, you need their help in Florida. So yes, we did do that, and that was our intent if we got nowhere. But we have been waiting patiently, in my mind, very patiently. That is a monstrous sailboat sitting against our beautiful house that we've only been in 8 years. It's a beautiful house. If you go inside the house, one of the main bedrooms in the front of the house. That's all you see out the thing is that boat. And if you go to the upstairs bedroom facing that, you see the mast and those torn up sail things. So it's definitely ruined the view. And plus, it's huge. You're trying to walk around the yard. Even the yard guy who been mowing our yard he was mowing it before we even had the house.
Just a couple more questions. If the special magistrate finds you in violation and orders that the property come into compliance, how much time do you need to have that boat disassembled in your backyard and removed?
Okay, that's a two-part question in my mind. First off, what you said was, in fact, you said that we threatened you with lawsuits and all that stuff. But what we received from our perspective is you guys threatened us with $250 a day fines for something we had nothing to do with. And you said you were going to do it. And you've taken months to do this once we actually got anything from you.
My question to you was, how much time do you need to remove the boat if you're found in violation? For all I know, the special magistrate won't find you in violation. I'm asking you, if he does find you in violation.
Well, I guess just the natural business negotiator in me says, at the very least, the amount of time the city's already wasted. So 6 months, I guess. And I'm going to have to figure out how to get that boat out of the backyard and how to do it. And if you do it, and I don't know, to me, there'd be no reason for that to happen, but it's not our boat. We didn't put it there. We had nothing to do with it. We weren't even in the country. And I don't think a civil court would.
Thank you. You've answered my questions.
All right.
All right, sir, I do not have any questions. Do you have any other witnesses? Ms. LaPointe, would you like to come up and provide some information to me today?
I'm just wondering whether the report that we got from the sheriff department, if that was going to be admitted as evidence, because that boat had been sitting out in a bay much further away from our house when it was tagged. It was tagged 2 or 3 times. And the tag was saying that it was going to be removed and salvaged. And that owner was not held responsible for what he didn't do. And here we are responding for something that he did. Is the report that we got from the sheriff department, is that going to be admitted as evidence?
Yes, there's 2 reports. There's one dated August 10th, 2024, and one dated August 21st, 2024. They're both admitted into evidence as exhibit number 6.
Thank you, sir. I just wanted to make sure that was, because Mr. Trask was saying that it was,
He was saying it's irrelevant. I understand
relevant.
his objection. I overruled his objection.
Thank
I'm
you.
giving you the benefit of the doubt and bringing him into evidence. So
Thank you.
don't go anywhere now. Mr. Trask gets to ask you questions. I don't know if he'll have any, but he
No other
does.
questions?
okay, thank you, sir.
Okay, Ms. LaPointe, Mr. Lewis, is there anything else you want to tell me? I'm going to open it up to public. Well, I'm going to go ahead and see if the city wants to call any rebuttal witnesses and then open it up to public comment. Is there anything else you guys want to tell me at this point? I'm going to give you the final word after the public comes up. Come on up to you speak in the microphone, sir.
Yeah, we have a ton more of video on our phones and pictures on our phones if those are of any interest to anybody. I thought because of the deputy fire chief basically endorsed the fact that the chains were theirs, the ropes were theirs, all that stuff. I didn't think that you needed more pictures.
No, I
He
understand
said
your
he took
argument.
The high rolling vehicles out there. So a lot of the pictures to me that neighbors sent us, the videos, we got a bunch of videos sent to us.
Sir, I don't think I need those because I understand the argument that
Yeah,
you're making. If I can distill it down, if I understand your argument, it's not your boat, you didn't create it, you're not storing it there. If I understand your argument, it's both a combination of the Pinellas County Sheriff, I guess, and the city fire department that somehow got this boat onto your property, and it should be somebody else's responsibility to remove it. Did I summarize your argument fairly?
That's a great summary, sir.
All
Thank
right.
you.
That shows I'm following along here and I understand.
Yes,
Okay. Mr. Trask, do you want to call any rebuttal witnesses at this time?
No rebuttal witness.
All right. If there's anything after public comment, I'll give you the other chance to do it. All right. Mr. Lewis, you just sit aside. I don't know if there's any members of the public that want to comment, but if they are, this is the portion of the hearing where any members of the public that have knowledge about Code Enforcement Violation 25-137 for the property located 913 Bay Point Drive can come forward. Any members of the public? All right. And ma'am, remind me, were you already sworn in this case? Okay, Mr. Trask. No problem. Mr. Trask, can you please swear in this member of the public?
Raise your right hand. You swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you.
And ma'am, what is your name?
Lori Hopkins.
Can you bring the
Lori?
microphone down?
Oh, sure.
Yeah, Lori, and then last name?
Hopkins.
All right, Ms. Hopkins, what would you like to tell me about this code violation?
I've lived at 912 Bay Point Drive about 32 years. I'm directly across the street, so I'm not one of the neighbors in the back where I view the sailboat, but I was home. I'm in a 3-story. When I went up to the window and looked out, I saw the high water. The day before the storm, it was probably 2 or 3 in the afternoon. Then I saw a truck come by. I realized later it was the American Legion high water truck. And I saw some people jump out over there. They went in the back of that property at 913, and I don't know what they did. I heard later that a neighbor a few doors down had seen a boat out floating in the open waterway and was nervous about the storm, called it in. And so I guess when they came out, they decided to tie it to this private property. And then the truck drove away. So I guess my main concern, I was sitting working at my computer and I was listening to this meeting online. And my main concern was that any of us, you, me, any of us, could be involved in getting ready and preparing for a storm, maybe at home, maybe not, but that a member of the public could come, put a foreign object on our own property, maybe without our permission or with it, tie it up, cause damage, which I can understand safety, why that would have been very necessary for our city to do that. My concern is that when you get to a week or two after a storm, you start to pick up, you clean up, you try to get things back to normal. We had probably 11, 12 boats floating like a river up and down our street during that storm. They were going everywhere in every yard. The sheriffs worked very hard to, and I'm just speaking from my heart because I didn't prepare. I just literally drove here when I heard the meeting. So they worked very hard and got every boat out of all the yards, tried to find the owners. But this boat was never taken care of. It even became a tourist attraction when everybody would come to the end of the cul-de-sac, stop and take pictures and say, what's going on with the boat? And I even asked code enforcement when they drove down the street, what's going on with this? And they said, we can't do anything. It's not in the waterway. It's on a private property. We can't do anything. So I guess I'm just saying, I'm concerned if this were to be where any of us as a homeowner would be responsible for this kind of an action when the person who tied it up for safety didn't then come back later and try to solve the problem and get things back to normal. And that's basically the point I wanted to make. I'm also, as a citizen, a little bit concerned that when the corrective actions were sent in on 2 different times, the city never responded back either time to those. That also concerns me, but that's all I'd like to say.
Thank you for your comment.
You're
All right. Are there any other members of the public that would like to come forward? See, Mr. Lewis, this is why you have to testify into the microphone so the public listening can come in and support your arguments. All right. Are there anybody else that wants to provide public comment? All right. Mr. Trask, I'll give you the last word on this one.
So it's clear that there is a violation of the cited code section. There is an abandoned boat that is on the LaPointe's property. They have testified to it not being theirs. It is a violation of section 14-69, paren 2. We're asking that you do find the violation, order the property be brought into compliance within 30 days, and should it not be brought into compliance within 30 days, that a fine of $250 a day be established for every day the property remains in violation of the cited code section. And with that in mind, I just want to address the issue of who put the boat there or how it arrived there. In our mind, legally, it does not matter. It would be the same thing as if somebody drove up into Mrs. LaPointe's driveway and left their car there. Or somebody has went into a vacant field and dumped off a whole truckload of construction debris. It is no different than what has happened here. It is obvious that the fire department did what it was supposed to do to protect life and property by tying that boat down so it couldn't further damage the LaPointe's home and Mr. Lewis's home or any other home. I think that was exactly what needed to happen. But it's clear that the only person that has control of the property that Mr. Lewis owns and Ms. LaPointe owns is them. They're responsible for this inoperable boat that's on their property that they have adorned with whatever. It is their responsibility to remove it. I was glad to hear from the testimony from Mr. Lewis that he has a relative that's in the salvage business, has told him how it can be salvaged. But I understand that there is some cost associated with that. Like any other code violation that needs to be corrected, there's cost associated with it. So we're asking that you find the violation and order the property be brought into compliance. I did ask, as you heard, how much time Mr. Lewis needs to bring the property into compliance. 6 months is unreasonable. We're going on 18 months that the boat has been in his backyard. It's time to have it removed. So that's my closing argument.
All right. Thank you, Mr. Trask. Okay, come on forward, ma'am.
Mr. Trask is saying that because the boat is in our backyard, it is our responsibility. And that we are responsible for moving the boat, for removing the boat that's there. It is not our responsibility because we did not authorize the fire department or the city to place that boat on our property. It's private property. It's not city-owned property. So if the fire department decided to borrow our property to store that boat, they didn't get our permission to do so. If they did it because of the fact that they were trying to prevent further damage, they should have done that when the boat was just sitting out in a bay. Out in a bay. That was the proper time to take care of that, especially after it's been, the boat owner had been warned a couple of times. They've been tagged to remove the boat and they have not been removed. That should have been the proper time to remove it so that it doesn't pose future danger to the properties on that bay. So when he's saying that's our responsibility, if the city would pay for that boat to be removed, I would agree with that. But as far as us paying to get it removed, I don't think so. I don't think that it is for us to do so. We never gave a permission to use our property to store that boat because the city did that, not us. If somebody comes and places their car in our driveway, the example that Mr. Trask used, if they park their car in our driveway and abandon the car, that car registered to someone, and we can find that owner and have them remove the car. It's the same concept with that boat. We didn't bring it there. They placed it there because of the fact that they were trying to prevent the boat to create more damage. So why are we being held responsible for that? He's saying that we should be responsible for removing it. I don't think we should be, sir.
I understand your argument, ma'am. As I said in the outset, my role here is very limited. It's not to assign liability or fault or anything like that, to the extent that if you believe you guys have a claim against the city fire department, the Pinellas County Sheriff, my role is not to make that determination. My role is very limited. It's to determine whether or not a specific code provision has been violated. And in this case, it's the city's position that irrespective of how the boat ended up there, there's currently an abandoned boat that is being stored on your property. I understand your arguments. This is different than a lot of the cases that come forward to me where it's somebody's own boat that they keep on their property and it's derelict and sinking and whatnot. This is different. However, Mr. Trask's analysis of the law is correct. It doesn't matter how it came to be on there. The question for me in this role, wearing this hat, is whether or not there is currently a code provision that's being violated. And in this case, the city's position is that the fact that that sailboat is on your property and it's abandoned is a code violation. Now, I believe the city has met their burden to prove that. Now, that doesn't mean that the owner of the boat isn't responsible to you from a liability standpoint. I'd have no opinion as to whether or not you have claims against the fire department, Pinellas County. I have no opinion on that. I'm not your lawyer. I would encourage you to talk to a lawyer about that if you think you have claims. I also am not unsympathetic to the fact that it costs money to remove this. I heard your testimony on that. And so I'm willing to work with you in that regard and provide you additional time to bring this into compliance. But to me, the way I look at it is, and again, if you believe that it's the fire department that put that boat on there, then please speak with counsel about that. But my role is limited to determine whether or not there's a code violation based on the evidence I'm going to find that there is. However, I'm going to give you more time. I'm going to give you 60 days to bring the property into compliance. I don't know, maybe you want to go out and talk to a salvage company that can come in. Maybe now that the hurricane's done, the cost is going to be less. Maybe they remove it for free because they take ownership of it and they salvage it themselves. I don't know. I'm also not going to do a $250 fine. I'm going to do a $25 a day fine. All right, so I'm going to give you an incentive to get it removed, but I'm not going to penalize you for having this boat in your backyard to the extent that you didn't create the situation. Now, what I'd also encourage you to do is just like what I told the prior folks that were in here. Please come to your next city commission meeting. If you think I've been unfair to you and you think that the city should take responsibility for this, then I would encourage you to come and express that to the city council. But my role here today is to determine whether a code has been violated. I do find that the issue is not whether you supplied a plan to them. The issue is whether or not the boat exists and it's an abandoned boat it's currently sitting on the property, and I find that there is. So again, I'm going to go ahead and I'm going to send an order, 60 days to bring it into compliance, $25 a day fine thereafter. If you need more time, 60 days go by and you need your brother-in-law to come do some work on it, you need another 30 days, come back and see me. I'm here every single month, and I'll be willing to give you more time. But I also understand the city's position that they don't want it this close to your house. They don't want another hurricane coming in and knocking your house down or something.
Let me just ask something pertinent, because in my mind, that boat has somebody's name on it, Richard Tixery or something like that. Do we have any authority to cut that boat up into pieces because of you're giving us the thing?
What I can say is I can't give you legal advice, but I would suggest you pick up the phone and call a local lawyer in town here who can talk to you about that. And again, I'm a big fan of telling everybody that comes before me to get legal advice and what you can do. And maybe it helps your situation that you're going to be subject to this fine and there's been a code enforcement violation. I would suspect that, yes, there's some liability on part of that person. Whether you can find that person or not, I don't know. In reading the report that you put into evidence, it looked like there was some warrant out for his arrest and he was arrested at some point. So I don't know whether you can find him or can't find him. I also noticed in your report that there was some dispute over whether or not the person, Richard Teixeira, really owns it or it's the prior person. Again, I would encourage you to go talk to a lawyer and come up with who you believe is responsible for payment. All I can do today is determine that a city code has been violated, give you reasonable time to bring it into correction, and that's what I've done here today, sir. So I've heard everything you said. I understand your argument, but that's my ruling.
Well, after hearing Mr. Trask, I have one more thing to add to your study of this, and that is it's not correct that the city has impunity, pure impunity about anything they do.
I'm not disputing
Under
that.
sovereign immunity laws, they do not have pure impunity. So for him to make the declaration that because it violates code, they have no responsibility to, that's like saying that the fire department went out, call for a fire, they go to the neighbor's house, start hatcheting up the roof and wetting it down and ruining it, and then halfway through it, they find out, oh, shit, this is the wrong house.
And again, sir, I'm not here to, let me just cut you off because I've made my ruling and we need to move on the agenda. Again, I encourage you to go see counsel. If you don't like my ruling, please feel free to appeal it. You have appeal rights. It's in the notice. You're welcome to appeal my ruling. Maybe there's a judge above me that says I'm wrong and you're right. So you have all those appellate rights. So remember that. But that's my ruling for today. I'll send you a copy of the order. I will send it to the make sure I've got the right address. The 913 Bay Point Drive address will be where the order goes. Okay?
Thank you.
All right. Thank you for your time today. All right, let's move on to the next matter on the agenda, CE 26-27, and this is for the property located at 13313 Second Street East. Is the city ready to proceed?
We see who these people are here for. If this is not their case, maybe move them
Sure.
up. They've been waiting a long time.
Which case are you guys here for?
That's D.
All right, we'll go ahead and, based on Mr. Trask's statement, let's move you guys up. So we will now call CE 25-157 for the property located at 13414 Gulf Boulevard. Is the city ready to proceed?
The city's ready to proceed. The city would call Taylor Davis as its witness. Taylor, if you could state your job occupation and your job responsibilities here at the city.
I am a permit and code compliance specialist for the city of Madeira Beach. I create code violation cases, post-stop work orders, just as a few.
All right, are you familiar with this property at 13414 Gulf Boulevard?
Yes,
And is this case a proactive case or complaint-driven?
this was proactive.
All right. And who is the owner of this property, and how do you know that?
Pinellas County Property Appraiser's Office, Paul Trader, and a Catherine Trader.
All right. And if you could turn to page 127 of the agenda packet, tell me, is that the printout that you made from the Pinellas County Property Appraiser's Office showing the owner of the property?
I have it on 244.
Okay. So this is where I had mentioned prior to the meeting that the city's agenda package, they doubled up all the cases. So they're in two different locations in the agenda packet.
Okay, so I'm looking at pages 244 through 270? No. Yeah, 270, is that what I should be looking at?
$244, yes, to 270.
Okay.
All right, this is going to be so confusing. Can you just go to agenda 5A, item 5A, and then go to page 127?
Okay, I'm there.
And just tell me the last page you're going to ask about, Mr. Trask, so I can pull that out for our
Okay.
exhibit.
Just want to make sure she gets on it. You got 127?
Yeah,
Okay, and that's the same case that we're talking about?
yes.
Okay, so we're gonna go from here on 127 on the packet. It's gonna go to 153. Okay. So, what was the violation on this property?
This was 8652, working without a permit.
Okay. And you said this was a proactive case?
True.
Okay. And who was the person that did the inspection on this property? to begin
Me.
it?
Taking pictures from outside,
You were?
yes.
Okay. And when did you first go to the property to take photographs?
Just before the courtesy notice letter was sent out, November.
If you could turn to page 136, there's some photographs there. Are these photographs that you took?
Yes.
You can explain what is happening or what is shown in the photographs that start on page 136 and continue on after that?
And they're also time-stamped for October 30th. So you see new flooring, you can see it in the boxes on page 136. You can see, I believe that's new trim. And then you can see some new sheetrock outside, also page 136. And some on page 137 as well. And then new blinds. You can see drywall cutout on 138. And more new flooring and trim.
Okay. When you found this violation, did you issue a courtesy notice of code violation?
Yes.
All right, and when did you do that?
November 3rd, 2025.
Is that starting at page 134 of the packet?
True.
When you sent the courtesy notice, how did you send it?
This one was regular mail.
When you sent it, did you specifically provide a corrective action that needed to be taken?
Yes. Property owner or licensed contractor will need to apply for and obtain an after-the-fact building permit.
Okay, and did you give a time frame to do that?
We gave them 2 weeks, November 17th for a compliance date.
Okay. In your estimation, did the work shown that was being done or had been done, did it exceed $500?
Yes.
When you sent the courtesy notice, did you send the copies of those photographs that you testified to a moment ago attached to that letter?
Yes, they were attached.
All right. Did the property owner bring the property into compliance by getting the building permit as required by November 17th?
No.
Has there been a building permit issued as of today?
No.
Has there been an application for a building permit filed?
As of today, I don't have anything.
All right. Did you issue a notice of code violation on November 18th?
Yes.
And is that reflected starting at page 139?
Yes.
Did the property owner, was that sent by regular or certified mail or both?
The notice of code violation was just certified mail.
Okay. Did the city get the green card back?
We did not. Oh, yeah. No, it wasn't signed.
Okay. Did the city then issue a statement of violation and a request for hearing for today's hearing?
Yes.
And is that in the agenda package starting at page 148?
Yes.
In that statement of violation, did you continue to cite the violation as section 8652, failure to have a building permit?
Yes.
All right. Did you also issue a notice of hearing for today's hearing?
We did.
And what date was that done?
That was sent on March 27th, 2026.
Did you also post the property and post City Hall with the notice of hearing?
Yes, same day.
Okay. Did you take photographs of the postings of the property and the City Hall?
Yes,
And
shown on page 152.
Okay. So as of today, there is no compliance with this code section. The property owner has not applied for and obtained a building permit for the work
Correct.
done. Okay. How much time do you think it will take to pull a building permit to get this work done?
30 days is reasonable.
Okay. And if the property owner, well, first of all, let me back up a little bit. Is this a property, is it vacant or is someone living there?
I see cars there every time I drive by, so I don't know if it's actively being rented, but there's somebody there daily.
Okay. Should the property owner not bring the property into compliance within those 30 days, what do you think a reasonable daily fine would be?
$250 a day if it's being rented for 30 days, or fines accumulate after 30 days, sorry.
All right. And what if the property is not being rented currently, or it's not being occupied? Do you think the fine should be the same amount?
I don't know if or when the property owner is going to use it as a rental. So it's a hard question.
Okay. All right. I don't have any other questions for Ms. Davis. I would like to tender into evidence pages 127 through 153 of the agenda packet and ask that it be received into evidence.
All right, I'll go ahead and receive into evidence as exhibit number 1, pages 127 through 153 of the agenda packet. Okay, who would like to come forward on behalf of the respondents? All right, sir, you've been very patient. What is your name?
All trader.
All right, sir. Just as you saw in the prior hearings, this is your opportunity to ask Ms. Davis questions about her testimony. I'm going to give you a full and complete opportunity to explain to me whatever you want to explain to me after the city's done putting on their case. Do you have any questions for Ms. Davis?
I don't have any questions, no. I acquired the property in July, and we're trying to get them fixed up and looking nice, and it used to be my parents' place, and we just want to make it right, get everything permitted up to code. and just whatever we can do to work with that. I also have my contractor here to, we were on the assumption that permits were being made and he was having issues apparently with the MGO site, which he could explain to you, but sorry, I have a cold.
That's okay. All right, so no further questions from Ms. Davis right now? All right, don't go far. I don't know if the city has any other witnesses or not.
The city has no other witnesses.
All right. Okay, sir, this is your opportunity in the hearing to tell me anything else you want to tell me. Obviously, I heard what you just said. Are there anything else you want to tell me? And you're free to call your contractor. He can come talk to me as well.
I know.
Anybody else on your behalf, if you want to show me pictures, anything you want to tell me, you can tell me.
I have questions for Mr. Trader before he sits down.
Okay, hold on. What are we doing now? Are you just going to call your contractor, or do you have any?
Yeah, that's all.
Okay, then, Mr. Trader, go ahead. You made some statements, so Mr. Trask can ask you some questions.
Sir, you're the owner of this property, correct?
Yes.
Okay. And is the property currently occupied?
The front one, a friend of my parents is staying there, an elder gentleman.
So is this a duplex?
It's 2 units. It's not a duplex, 2 separate units.
All right. So there's 2 different rental units on this property, correct?
Yeah, there's a 600 square foot and 400 square foot approximately.
Okay. And so you've seen the photographs that are shown up on the screen today. Is this in the unit where it's currently being rented?
I'm not sure.
All right, we're going to pull the photographs back up.
No, that's the other one.
All right, can you bring the microphone down in front of you so we can hear what you're saying?
No, that's the rear one.
Okay, so the photographs are of the rental unit. It's your testimony under oath today that no one is occupying that unit, correct?
Correct.
Okay. All right. What work is being done in that unit?
Mostly just flooring and drywall. The contractor would have a better understanding of that, but
Didn't you hire the contractor?
yes.
Okay. Did you sign a contract with the contractor?
No,
It's all verbal?
pretty much.
Okay. So what did you tell him you wanted done?
Just get it fixed up, drywall, floors.
Okay. Why is the drywall cut out?
From the water.
Okay, so when you
We had
say
to
water,
replace-
was there water damage to the unit?
Yeah, had to replace the insulation.
Okay, so
Yeah, flood damage.
all of the drywall in the unit was taken out?
No.
Okay, so how much drywall was taken out of this unit?
You would have a better answer, I'm not sure.
Have you not been to this property to see what's been done to it?
4 feet, he said.
I'm sorry?
4 feet.
Okay. Sir, if you could sit down for a moment. This isn't about you, okay? So these questions are to you. If you don't
Okay.
know the answer, you can tell me you don't know the answer.
Okay.
Okay. Did you replace kitchen cabinets?
Yes.
Okay. Did you replace or remodel the bathrooms?
No, the front one had a little bit, but the back one, nothing was done to.
Okay. So besides the
Vanity, I'm sorry.
Okay, so one of the vanity in one of the bathrooms?
Yes.
Okay. So any sinks replaced?
I believe the sinks were new.
Okay. Any electrical work done in the unit?
No, just outlets.
What do you mean, just outlets? Outlets were
Outlets.
replaced?
Yes.
Okay. Any lighting fixtures replaced?
Yes.
Okay. You agree that the work that's been done on your property is valued in excess of $500, don't you?
Yes.
Okay. What have you done to pull a building permit for this work that was done?
I just asked him to take care of it.
Okay. So,
And I've came down here twice, actually, also to talk to people, Connor and, not Stephanie, the other lady there, starts with S.
okay, so
Samantha.
you don't live here in Florida then, is that what you're
I
saying?
live in Florida,
Okay, when you say you're coming down here, where do you live?
Seminole.
Across the bridge?
Mm-hmm.
Okay. All right. What's the reason, it being now April, 6 months have passed since the original violation was cited? How come an application for a building permit has not been attempted in the last 6 months?
Don't know.
Okay, thank you.
Yes, sir.
All right, sir, I don't have any questions. Would you like to call your contractor up to
Yes,
testify?
please.
All right. Sir, what is your name?
Tom Hatton.
Sir, how do you spell your last name?
Hatton.
All right, Mr. Hatton, what would you like to share with me about the code enforcement violation that brings?
I'm the reason that the permit's not fully in place, not the owner. We took on too many properties during the flood, and it's just been confusing with the MGO system. But we have, right now, we're in the process of, I should have the permit completely in the MGO system by tonight. And I've also got an electrician to sign on. The only thing that was replaced was outlets, but I got an electrician and an AC guy and a plumber if needed to sign on, but then by tomorrow. So
All right.
we don't need 30 days. We just need another 24 hours or 48 hours.
Mr. Trask?
Sir, are you a licensed general contractor?
I work with one, yes.
That's not what I asked. Are you a licensed
No,
general contractor?
no, sir. I work for the company. I represent the company.
Okay, what company is that?
Papasop.
Help.
Papasop.
Okay. How many properties have you been working on in Madeira Beach?
On Madeira Beach, just that one right now, and one other.
All right.
Most of our work was in the city and on Treasure Island.
So what's the reason in the past 6 months since this property has been cited that you haven't pulled a building permit?
Well, we tried twice on the MGO system, and I guess we have someone that pulls them for us. And I really can't give you a great answer except that it's slipped by.
Did you stop doing work on the property once the notice was issued?
Yeah, we did stop.
Okay.
And we did some other work afterwards though, but we did stop. We stopped initially, then there was someone going to move in, just being honest with you, moving into the property, the friend. So we did a few more things so they could move in, but we haven't finished the properties.
Okay, the unit that we're showing the photographs of, has that unit been completed?
Not completely. I don't think any of them are, no, not completely.
Okay. Thank you.
Okay, I don't have any questions. All right. Sir, are there any other witnesses you would like to call or anything else you'd like to tell me today? You don't have to if you don't want to, but if you are, this is your opportunity. Is that a no? No, sorry. Okay, no other witnesses. All right, if there's any members of the public that have knowledge about case number CE 25-157 for the property at 13414 Gulf Boulevard, now is the time to provide public comment. Seeing none, we'll close public comment. Mr. Trask, anything else?
No, I don't have anything else. Thanks.
All right. Based upon the admissions of the owner and the contractor, I do find the violation occurred and is currently ongoing. I'm going to give you 30 days to bring the property into compliance. Thereafter will be a $250 a day fine if for whatever reason, sir, you find that you need more time than 30 days. Like I told the last folks, I'm here every month, but please come see me before that 30 days runs or as soon as close as you can if you have some issues with the permit. All right, so I'll go ahead and get an order and send that to you. And I'll send do you want me to send the order to the 10657 address or the 13414 address? Okay. All right, that concludes the hearing on CE 25-157. Okay, let's go back to case number CE 26-27 for the property at 13313 2nd Street East. Is the city ready to proceed?
Yes, we are. The city would call Taylor Davis. Taylor, this property, is this a proactive case or complaint-driven?
This one is complaint-driven.
Okay, what was the complaint the city received?
The next door neighbor, Scott, we have an email thread from him. He has been notifying us when the property is being rented out short-term. So we kind of assumed that it was redone, and then he provided us pictures inside, and then we also found it on Zillow for sale, all new interior.
Okay. So once you received the complaint, did you determine who the property owner is, and how did you determine that?
Pinellas County property appraiser owner is Red River Property Group, LLC.
All right. And are you looking at starting at page 102 of the agenda packet?
I am.
Thank you. All right. When you found out who the owner was, did you go out to the property and determine whether or not a violation existed?
Yes.
Okay. When did you go out to the property?
We went onto the property shortly after the first time the neighbor notified us of the renters, but the pictures are going to be from Zillow.
Okay. So when you went back to the office, I assume that you pulled up Zillow. How did you find this particular property on Zillow?
Just the fact it was for sale. We saw that it was bought in January, and I'm assuming flippers gutted it, redid it, put it for sale.
So you just plugged in the address here in Madeira Beach?
Yes.
Okay. All right. I want you to turn to page 110 of the agenda packet, and there's some photographs there. And if you could explain to me what these first of all, are these photographs taken from Zillow?
Yes.
Okay. And were these listed under the address of 13313 2nd Street East?
True.
Okay. And it looks to me like there's, well, why don't you explain the photographs?
110, the upper picture, you can tell it's different cabinets down below than it is up top. And then appliances look new. You can see new trim. There's actually like 3 different kinds of cabinets. And then the lower picture looks like brand new doors. And then page 111, again, new trim, new back door, new water heater, new vanity in the bathroom. And then page 112, you can see the property is for sale with all of those kind of same pictures in there.
Was there any information on Zillow saying this property was recently remodeled?
Not that I saw.
Okay. Would this been one of the houses here in the city that have received flood damage from the hurricane?
Yes.
Approximately how much water would have been in this house?
The area this home is in, about 3 to 4 feet.
Okay. All right. So once you found on Zillow that the property had been remodeled, did you issue a courtesy notice of violation?
Yes.
And is that what's depicted starting on page 108?
Yes.
When you sent that courtesy notice, did you attach all the photographs that we just went over?
We did.
Okay. Did you ever get a response back from the property owner?
No.
What was it that you were asking the property owner to do to come into compliance?
Have a licensed contractor, being that it's in an LLC, apply for an after the fact building permit.
All right. Did you set a corrective date, time, a follow-up date?
For the courtesy, March 3rd, yes.
Did it come into compliance?
No.
Is it in compliance today?
No.
All right. So the city issued then a notice of code violation?
Yes, we did. Shortly after that, March 3rd, it was sent out. Follow-up date, March 17th.
And you attached the same photographs as before?
Yes, sir.
How did you send that? Did you mail it by regular mail, certified mail?
Courtesy, regular mail, certified mail.
Okay. Did you get the green card back?
We did not.
Okay. Did you subsequently issue a statement of violation and request for a hearing?
Yes.
And is that reflected on page 121 and 22 of the packet?
Yes.
Did you also prepare a notice of hearing for today's special magistrate hearing?
Yes.
And is that reflected in starting at page 123?
Yes.
All right. And how did you send those, the statement of violation, the request for hearing, or the notice of hearing?
These were sent by regular and certified and posted at the property in here.
Okay. So it was posted at the property and city hall?
In here, yeah,
All
that's
right.
right.
Did you issue an affidavit of service reflecting all of those
We did.
notices? Okay. And is that reflected starting at page 119?
Yes, sir.
If you could turn to the last 2 photographs on this particular case and tell me what those 2 photographs reflect. It's page 125 and 126.
125 is the actual property. That is our posting of the affidavit of service, request for hearing, and statement of violation, and the address is kind of in there on the mailbox. And then page 126 is the posting of the packet downstairs.
Okay. How much time do you think it would take to get a building permit issued to bring this property into compliance?
30 days.
All right. And if it's not in compliance within those 30 days, what do you think the daily fine should be?
$250 for sure for life safety because they are renting it.
All right. I have no other questions. Thank you.
All right. Thank you, Ms. Davis. That was very succinct. Anyone here on behalf of the respondent? Anybody here on behalf of the owner of 13313 Second Avenue East who would like to come forward? Okay, seeing none, does the city have any other witnesses?
No other witnesses.
If there's any members of the public that want to come forward in regard to code enforcement case CE 26-27 for the property located at 13313 Second Street East, please come forward now. Seeing none. Anything else, Mr. Trask, on this one?
No.
Okay. I'll go ahead and find the property is in violation based on the testimony of Ms. Davis as well as the exhibit accepted into evidence. I'm going to give the property owner 30 days to bring the property in compliance. Thereafter, it'll be a $250 a day fine. All right. Let's move on to case number CE 25-167. This is for the property located at 515 129th Avenue East. Is the city ready to, and I called it as 25-167. Is the city ready to proceed?
Yes.
Go ahead, Ms. Trask.
The city would call Connor Mecco. Connor, if you could please explain to the special magistrate your occupation, your job responsibilities here at the city.
I'm a code compliance and permit specialist for the city of Madeira Beach, and part of my job entails citing code violations and enforcing them.
You familiar with this property at 515 129th Avenue East?
Yes.
And is this a proactive case or complaint driven?
This was complaint driven.
What was the complaint the city received?
We received a complaint from a tenant upstairs about the living conditions and some maintenance issues in her unit.
Okay. Did you go out to the property to see if there was a violation of city code?
Yes.
Okay. And when did you go out to the property?
We went out to the property in November. It was when we sent out the courtesy notice, so it would have been around November 14th.
All right, let's talk about the ownership of the property. Who's the current owner of the property?
The current owner is Absolute Control Trust.
How do you know that?
Using Pinellas County Property Appraiser.
Okay. Now, somewhere during the process of citing this case, the ownership changed, is that correct?
True, they're using quick claim deeds to move the property between LLC and trust names.
Okay, and what was the LLC's name just prior to Absolute Control Trust?
Real Estate Company, LLC.
All right. So when the case was originally came to you as a complaint, did you issue a courtesy notice of violation to Real Estate Company, LLC?
Yes.
Okay, and that was done on November 14th, 2025?
True.
Okay. So what was the violation that was cited in that courtesy notice?
General maintenance, which is section 1470, also 1471, which is the duties and responsibilities of the operator, and also 8652, which is when required for work without a permit.
All right. So when you went out to the property, did you take photographs of the property?
Yes.
Okay. I'm going to turn your attention to starting at page 162 and ask if you could explain these photographs.
So starting on 160, this is tile in the bathroom floor that is cracked. A big issue with this tile was it may not be able to be seen, but when standing on it, it's very spongy and not stable. That was one of her bigger concerns, is the instability of the flooring itself. 161 was from the shower, tile in the shower that's broken and cracked. And that's in the shower. This is on page 162. It's exposed wiring and electrical, and that's in the unit itself, next to the water heater, just all exposed. And then this was what she believed to be termite damage, and she noted that they had bug problems. She believed termite infestation in the property. And then 164 is where we posted a stop work order because there was work done in one of the bottom units where it was remodeled. I think that picture, the updated picture that was taken, is in that second, how you were saying it was double posted. I think the revision including that picture is probably further down in the packet. I could try to find the specific page.
Yeah, why don't you do that, because I did not print out two copies of the same thing.
So page 302 of the packet. This picture is of one of the downstairs units, showing work done, which is what prompted the 8652 for work without permit. As you can see, and this was taken from outside, but you can see through the window that there's new cabinetry, new appliances, and also the drywall trim and flooring and everything is brand new. This property received probably anywhere between 3 to 4 feet of water from the storm. So this is all done post-storm.
All right. So when you issued the courtesy notice of violation, did you attach these photographs that you're talking about?
Correct.
Okay. Is the property in compliance as of today?
No.
Okay. Did you issue a notice of code violation then for the property?
Yes.
Did it cite the same code sections as the previous notice?
Correct.
Did it attach the photographs that you just testified to as well to the notice of code violation?
Correct.
Did you send it by certified mail?
True.
Okay. So what does the property owner need to do to bring this property back into compliance?
So the property owner would need to obtain a building permit. They would need an after-the-fact permit for the work done downstairs, and also they would need to resolve the issues in the upstairs units, the maintenance issues, such as the cracked tile and damaged subflooring and the exposed electrical.
Okay. And in fact, you list out in your notice of code violation the exact requirements for the property to bring the property into compliance, correct?
True. On page 174, you
Thank
can
you.
see the violation details and corrective action.
All right. So since the property did not come into compliance, you prepared a statement of violation request for hearing for today.
Yes.
That was done on March 27th.
True.
You also prepared a notice of hearing for today's hearing,
Yes.
and that was also done on the same date, March 27th this year?
Yes.
Okay. Did you also post the property in at City Hall?
Correct.
Okay. And did you issue a affidavit of service that would reflect all of that?
Correct, on page 181.
All right. So how much time it would take to bring this property into compliance?
30 days.
What if it's not in compliance in 30 days? What do you think the daily amount of the fine should be?
I believe $250 a day for life safety issues because it is presently being occupied by tenants upstairs.
Okay. All right, thank you. I don't have any other questions for Connor. I would tender into evidence pages 154 through 184, ask that they be received into evidence.
All right, I'll go ahead and accept into evidence as Exhibit Number 1, pages 154 through 184, and then as Exhibit 2, I think it's page 302 of the agenda packet, which is the picture of the violation showing the work without a permit.
Thank you.
All right, is there anyone here on behalf of the respondent, Absolute Control Trust, or anybody here on behalf of the owner of the property at 515 129th Avenue East? Okay, let the record reflect there is nobody present on behalf of the respondent. Are there any members, or anything else from the city, Mr. Trask?
No, thank you.
Are there any members of the public that have information about code enforcement violation 25-167 that want to come forward? Being none, we'll go ahead and close public comment. Mr. Trask, anything else on this one?
No, thank you.
All right, based upon the testimony of Mr. Mecco as well as the documents accepted into evidence, I go ahead and find there is a violation or are violations as set forth in the order. The respondent will have 30 days to correct the violation or $250 a day thereafter. I saw the notice was certainly proper under the property appraiser's website. On this one, is Absolute Control Trust is an actual trust, Mr. Trask? Is it an LLC? Is it a I mean, do they have a registered agent in the state of Florida? I just want to make sure if they do, I serve it on the registered agent to maybe compel some action as well.
I have the deed that was issued on November 19th, and it has an address in South Dakota. I can provide that to you.
Yeah, will you just read that on the record, and I'll just
Right.
put that in there?
So this is Absolute Control Trust, a South Dakota trust, whose mailing address is 204 South Main Street, Sioux Falls, South Dakota. The zip code has too many numbers. It says 571043.
Okay, we'll figure that out. I'll look it
Okay.
up. All right, I'll also go ahead and send a copy of the order to that address, just so that there's no question about it. All right, I think that concludes everything in new business. We just got one matter. It's old business. Is that correct, Mr. Trask?
That's correct.
All right. The next case we'll call then is 25-178 for the property located at 575 Normandy Road. I received what you provided to me, that is a copy of my order as well as a request from a Twin Yin to Mr. Mecco. So go ahead and proceed how you'd like, Mr. Trask, on this one.
Yeah, Judge, this is a request for a extension of the compliance date. The city has no objection to a 60-day extension of the compliance date. Well, the compliance date right now is set pursuant to your order, March 26, 2026, so 60 days, put it May 26, 2026. City has no objection to that.
I will go ahead and enter. Anybody here from the respondent? Okay. Based upon your representation, Mr. Trask, I'll go ahead and accept as exhibit number 1 the email and the order, and then I'll go ahead and enter an order granting the respondent an additional 60 days to bring the property into compliance, which will be on or before May 26, 2026.
Thank you.
All right. Are there any other matters before me today?
That's it.
All right. That concludes today's hearing. Thank you very much.
Thank you.